Good morning, everyone. This is Ella Rosenberg from ICSID. I'd like to welcome you to day 3 of this hearing. Professor Armesto, it looks like everyone is connected. We also have the United States connected this morning, and I see cameras on from Ms. Thornton and Mr. Daly from the United States.
Excellent. Thank you very much, Ms. Rosenberg. This is then the 3rd day in the jurisdictional hearing in the ICSID arbitration between the Carlyle Group LP and the others against the Kingdom of Morocco. It's ICSID case arbitration 1829. We have the USA waiting. There has been one submission, and I will say we will address it later on, but just so that everyone can slightly relax. We have had a request overnight from respondent, and we are not going to address it today because it is would be too onerous on claimant and giving all the time difference. So we will give claimant a reasonable period to react, and we will then in due course take whatever appropriate decision is. So if this is the question of the SEC filings of claimant, we will decide on that, and if then, assuming we decide that these documents are necessary, we will then give the parties opportunity to address them in writing at a later stage. But to do it today, overnight, with a time difference, we thought it would not be a fair way of carrying out the day. So but that is, we will discuss it later on. I don't want to have the USA waiting. So we will now start.
Mr. President?
Yes, Mr. Ortway.
If I may, I'm not going to take more than a minute of time here, but I would just like to make a statement because it may affect the statement of the United States, if I may.
Of course, Mr. Ortway.
And really, it's very simple. This is not a transcript correction, but a misstatement that I made on January 13th. And I would simply like to correct it so that it's understood by the respondent, the tribunal, and of course, the non-disputing party, the United States. On January 13th, and this is page 184 in the transcript, lines 20 to 25, I made a statement concerning, I said, to the extent that the U.S. has raised this issue, and the issue in connection with that was 1015-1A, I really made a misstatement because I said to the extent that the United States has raised the issue. In fact, what I intended to say, and I misspoke, was that the issue, to the extent the issue has been raised in NAFTA cases, in 5 of the 6 instances, the issue was rejected. So I just want to make that correction because I attributed to the United States more of the submissions than they actually made. And some of those, because it was a NAFTA case, were made by Canada. That's my sole change with regard to that. And then perhaps when we go to the breakout session, I'll give you one other slight change. And I can comment on what you said previously. But I don't want to interrupt the United States or delay the United States' presentation in any way, but I wanted to make that correction. Thank you.
Thank you, Mr. Ortway. Very good. Thank you for your correction. Then, without further ado, I see Mr. John Daly, and I see Miss Nicole Thornton, and I see Miss Lisa Grosh for the USA, and I don't know who will be speaking. In any case, I give them the floor in accordance with Article 1019-2 of the FTA. Good morning to you.
Good morning. I will be making the presentation this morning. Thank you very much. Thank you, Mr. President and members of the Tribunal, for this opportunity. My name again is Nicole Thornton. I'm the Chief of Investment Arbitration in the Office of International Claims and Investment Disputes at the U.S. Department of State. The United States, of course, makes its submission on issues of treaty interpretation pursuant to Article 1019-2 of the U.S.-Morocco Free Trade Agreement, or FTA. The United States does not take a position on how these treaty interpretation issues apply to the facts of this case. Moreover, as is the case with every statement we make as a non-disputing party in this and all other cases, no inference should be drawn from the absence of comment on any issue not addressed in this submission. We have listened to the disputing parties' opening statements and would like to briefly address a few issues that were raised in addition to those addressed in our non-disputing party submission of December 4th. We would like to address three issues today, namely the subsequent agreement or subsequent practice by the FTA parties, the United States interpretation of NAFTA Articles 1116 and 1117, which was characterized on Wednesday as inconsistent with its present position on the interpretation of FTA Article 1015.1, paragraphs A and B, and the decision on respondents' preliminary objections in Capis v. Guatemala, a matter raised by the President on Wednesday. The first issue we would like to address concerns the shared interpretations of the state parties to the FTA as to its provisions and Articles 31.3a and b of the Vienna Convention on the Law of Treaties. Although the United States is not a party to the Vienna Convention, we consider that Article 31 reflects customary international law on treaty interpretation. States are well placed to provide authentic interpretation of their treaties, including in proceedings before investor state tribunals like this one. FTA Article 1019.2 ensures the non-disputing FTA party has an opportunity to provide its views on the correct interpretation of the FTA, and the United States consistently includes provisions for such submissions in its investment agreements.
Ms. Thornton, I hate to interrupt you, but you are going very fast for the court reporter. Could I kindly ask you to make some pauses? That would be appreciated so that the quality of the transcript is perfect.
Will do. Thank you, Mr. President. Article 31 of the Vienna Convention on the Law of Treaties recognizes the important role that the states parties play in the interpretation of their agreements. In particular, paragraph 3 states that in interpreting a treaty, there shall be taken into account, together with the context, any subsequent agreement between the parties regarding the interpretation of the treaty or the application of its provisions, and any subsequent practice in the application of the treaty which establishes the agreement of the parties regarding its interpretation. Article 31 of the Vienna Convention is framed in mandatory terms. Subsequent agreements between the parties regarding a treaty's interpretation and subsequent practice of the parties that establishes their agreement shall be taken into account. Notably, several investment tribunals constituted under NAFTA have agreed that submissions by the NAFTA parties in Chapter 11 arbitrations, including non-disputing party submissions, may serve to form subsequent practice. For example, the Mobile v. Canada Tribunal found that arbitral submissions by the NAFTA parties constituted subsequent practice and observed that the subsequent practice of the parties to a treaty, if it establishes the agreement of the parties regarding the interpretation of the treaty, is entitled to be accorded considerable weight. And I just point you to paragraphs 103, 104, and 158 through 160 of the decision on jurisdiction and admissibility dated July 13th, 2018 in that case. The tribunal in Bilcon v. Canada reached a similar conclusion at paragraphs 376 through 379 of its January 2019 award on damages, as did the tribunal in Canadian Cattlemen for Fair Trade. On Wednesday, we heard several arguments as to why the concordant interpretive positions of the United States and the Kingdom of Morocco, particularly with respect to Article 10.15.1a and b, either should not be considered subsequent agreement or subsequent practice, or should be disregarded. And we will very briefly address these in turn. First, claimants suggested that positions taken in the context of litigation do not amount to a subsequent agreement or subsequent practice. The International Law Commission's commentaries to the recently adopted draft conclusions on subsequent agreements and subsequent practice addresses this point. In these commentaries, the ILC explained that subsequent practice may include, quote, statements in the course of a legal dispute, end quote. That is from page 32, paragraph 18 of the commentary to draft conclusion 4 as adopted by the Commission in 2018. Notably, FTA Article 1019(2) submissions can only be made in the context of ongoing litigation, and the treaty parties clearly intended that such submissions would provide guidance to tribunals in their interpretation of the FTA. To conclude otherwise would render Article 1019(2) ineffective. Accordingly, where the FTA parties' submissions in an arbitration evidence a common understanding of a given provision, this constitutes subsequent practice that must be taken into account under VCLT 31(3)b. Second, claimants suggested that the FTA parties' agreement regarding the interpretation of the FTA should be disregarded because the parties did not issue an interpretation by the Joint Committee under Article 1021(3). Joint Committee interpretations are subsequent interpretive agreements with binding effect, but the fact that FTA parties provided for a special procedure for binding subsequent interpretive agreements does not preclude recourse to authoritative, though not necessarily conclusive in character, subsequent agreements or subsequent practice under VCLT Article 31(3) as established through other means, including, again, non-disputing party submissions pursuant to Article 1019(2). Third, the treaty parties' agreement regarding the interpretation of the FTA should not be disregarded simply because it is the first time the FTA parties have addressed Article 1015(1)a and b. A single statement or act by the FTA parties can, depending on the circumstances, establish a subsequent agreement or practice between them. The ILC has addressed this point as well, observing that, and I'll paraphrase here, while the formula concordant, common, and consistent may be useful for determining the weight of subsequent practice in a particular case, the formula is not sufficiently well established to articulate a minimum threshold for the applicability of Article 31(3)b and carries the risk of being misconceived as overly prescriptive. Ultimately, the ILC found that, quote, the value of subsequent practice varies according as it shows the common understanding of the parties as to the meaning of the terms. This implies that a one-time practice of the parties that establishes their agreement regarding the interpretation needs to be taken into account under Article 31, paragraph 3b, end quote. That is from page 73, paragraph 11 of the commentary to draft conclusion 9 on subsequent agreements and subsequent practice. Finally, on this issue, the United States offers a brief response to claimant's suggestion that the established agreement of the FTA parties should be disregarded as retroactive or unfair. There is no element of retroactivity here. The United States is simply providing its views in the course of a dispute as envisioned by Article 1019(2). The fact that the FTA parties have a concordant position on the proper interpretation of Article 1015(1)(a) and (b) does not change the text or meaning of those provisions, let alone do so retroactively. It is not an amendment. Rather, it is evidence of the provision's meaning. The interpretation set out in our non-disputing party submission is fully consistent with the ordinary meaning of the text. Moreover, as I will explain, the U.S. position on this issue generally has been known for at least 17 years since our 2003 submission in GAMI Investments v. Mexico, so there is no element of surprise. To sum up on this first issue, the concordant interpretations presented by the two FTA parties in this proceeding form either a subsequent agreement or subsequent practice under VCLT Article 31(3), and the outcome is the same. The tribunal must take the FTA parties' common understanding of the provisions of their treaty as evidenced by their submissions in this arbitration into account. Turning to the second issue, I would like to briefly address comments made on Wednesday that the United States historically took positions regarding NAFTA Article 1116 that are inconsistent with positions advanced in its non-disputing party submission in this case. Specifically, reference was made to our non-disputing party submissions in two early NAFTA cases, Pope and Talbot and S.D. Myers. Any suggestion that these submissions are inconsistent with the United States position on FTA Article 1015(1)(a) is incorrect and based on a misreading of those submissions. The issue in those cases was whether a claimant was entitled to recover losses that were incurred in capacities other than as an investor. Both cases involved cross-border trade. The distinction between Articles 1116 and 1117 was made in general terms. 2 years after our submissions in those cases, when a case arose in which an investor was seeking to claim for the losses of its subsidiary, the United States further clarified and expounded on this interpretation in its 2003 submission in GAMI Investments versus Mexico. And the United States has maintained that position since then. I would point the tribunal in particular to our second submission in 2017 in Bilcon v. Canada. We would be happy to provide the submissions if helpful, and they are published on the State Department website. On this issue, I would just underscore again that how an investment or a claim for loss or damage is characterized is not determinative of whether the injury is direct or indirect. Rather, as the International Court of Justice found in Diallo and Barcelona Traction, what is determinative is whether the right that has been infringed belongs to a corporation as a separate legal entity or to the shareholder of that entity. The United States has consistently maintained, including in its earliest NAFTA non-disputing party submissions, as well as the one in this case, that nothing in the text of the relevant provisions derogates from customary international law principles articulated in Barcelona Traction, apart from the very narrow and limited manner as described in our submission. Turning to the third and last issue, the Capes v. Guatemala decision on respondents' preliminary objections, which was raised by the President on Wednesday. Here, the United States wishes only to say that while we frequently file non-disputing party submissions, we do not do so in every case or on every issue that may be raised in every case. There are many reasons we may not file in a case, including, in some instances, lack of timely access to pleadings or resource constraints. Therefore, no inference should be drawn from the fact that we do not file a non-disputing party submission in a particular case or on a particular matter. This includes the decision of the CAPAS majority on the analogous provisions of the CAFTA-DR, a decision which we believe was wrongly decided. This concludes my remarks, Mr. President, members of the Tribunal, and we thank you for your time and attention to our submission.
It is us, Ms. Thornton, who thank you for your submission, and thank you very much. With that, I think we will now make a break so that parties have the opportunity to take into consideration the submission of the United States. It is now in Spain, 15:23. Shall we come back at 16 so that everyone has sufficient time to go through the transcript of Ms. Thornton's submission, and so that if anyone wants to make any comment to it in the course of the post-hearing in these final oral submissions, it can do so. If we find that these would be precipitated, that that we need a deeper analysis of the situation, at the end of the hearing, that idea of the tribunal is to give a list of certain questions which we would like to have addressed in writing. And so it may be that some of the issues raised by the United States of America, we can include them in that list, because I think that what Ms. Thornton has said is has a great. It is one of the basic questions of investment arbitrations, and so it deserves. That we all and the parties and the tribunal give it a very thorough review. So with that, shall we then come back at 16 Spanish time, which should probably be like 10 in the United States?
Mr. President, from my part, I will be obviously speaking next as making our closing. I'd be happy to take a break just for 20 minutes till 1:45. That would give me enough time.
Okay.
I'm conscious that we may need the time later, so I don't want to take additional time unnecessarily.
Okay, so then let's make it 1:45. But let me ask Mr. Ordway how he feels.
I believe that 20 minutes is fine as well.
Very good. So then we come back at 15:45 Spanish time, which would be 9:45 Washington time.
Very good. Thank you.
Ms. Thornton, thank you very much for your presentation and making the effort. Given all your restraints, which it is, I'm almost happy to hear that even the United States of America has some financial restraints, and so given that, we appreciate that you made the effort of coming here to us and providing us with the position of the United States of America. Thank you very much. So we resume the hearing. We thank the court reporter for her efforts in getting a first version of the transcript of the presentation by the United States of America. Thank you, Diana. And we now give the floor to respondent for its closing statement. Mr. Wait, before we do that, maybe it is now that we have the USA behind us. We had deliberated on this issue of the SEC filing. Is there any comment with regard to the solution proposed by the tribunal, Mr. Harris?
No, comment from us. We were trying to be helpful in response to your question. We're happy to deal with it however you prefer, sir.
And Mr. Ordway.
Yes, we are also pleased to deal with it however you wish to. However, we do also want you to know that the documents that respondent seeks to admit into evidence have already been introduced into evidence as claimants 58 and claimants 37. So the idea that somehow we should devote time to that now and introduce these items when they have previously already been introduced, I think, well, we're just a little puzzled by it, number one. We also have some issues as to why they would want to address that in their closing, since we had made a decision with regard to certain statements we made and with regard to the withdrawal. Our withdrawal was something that was the subject of respondents' comments in its the withdrawal of one of our claimants, that is, and respondents sought to make an issue of this, but it really should not be an issue, and I can go into that in my response. But I think that, again, however the tribunal wishes to deal with it is fine with us. Only thing we need to mention is the idea of introducing it as if it's not already in the record. I think is error, because it has been in the record.
Excellent. So we'll then solve it the way the tribunal proposed, and without further ado, I give the floor to Mr. Harris on behalf of the Kingdom of Morocco.
Thank you very much, Mr. President, members of the tribunal. Before I go any further, I'd like to make a few remarks by way of overview before we get into the detail. The jurisdictional hearing, really, and the jurisdictional case comes down to three questions in essence. First, can a party which had suffered only indirect loss, only reflective loss, claim under this treaty? And I'll come on to our submission on that shortly. As you've already heard from the USA, the Kingdom of Morocco takes the same approach. We say the plain text of the treaty confirms it cannot. And that is the end of the matter, because the claimant's own case shows you that it only claims, even in the further new unpleaded claim for loss that Mr. Ordway sought to introduce in his opening, even that was an indirect loss. So there are no direct losses claimed. The second question only arises if you are against me on the first question, and that is, does the evidence which the claimants have put before you on a balance of probabilities demonstrate that they concretely made this investment, that they contributed anything to it, that they took any risk, or that this was an investment with any real duration in the relevant sense? And the burden, however many times the claimants try and deny it, the burden is on them to satisfy you of those jurisdictional predicates, and to satisfy you by evidence, not assertion. And they have come nowhere close to discharging that burden. And it is important in that context to keep in mind that the claimants in this case are entities of one of the largest, wealthiest financial services groups in the world. They have hundreds of lawyers, hundreds of accountants from all the top practices all around the world, dotting every I, crossing every T, keeping meticulous records of the transactions they enter into. You heard Mr. Zuek yesterday telling you how conscious they are of making sure that there's no risk that they can get into trouble in relation to tax issues. They are very carefully monitoring what's happening. So if you don't have necessary documents before you, if documents have been left out, then there is a clear adverse inference to be drawn. And that adverse inference is all the more reasonable to draw in circumstances where, throughout this case, we have repeatedly drawn attention to specific documents and information gaps and asked them to fill them. And in many cases, where the documents still remain absent, they have determinedly and deliberately refused to produce the information. And as I'll develop shortly, the claimants haven't proved on the balance of probabilities, because they cannot, fundamental points relating to your jurisdiction. They have not established that they made any contribution to these transactions. Indeed, the only entity, the only claimant, which they even try to show making a financial contribution to some of the transactions is the onshore feeder. And Mr. Zueck accepted in cross-examination yesterday that the documents on which they rely show no such thing. Secondly, it is indeed common ground that the financing came directly from 2014-1 in 13 of the transactions. And no information has been produced about how Q1 allegedly acquired the underlying commodities in the remaining 3 transactions, the swap transactions. You have no evidence of that at all. It's also common ground that a large proportion, at least, we say all, but it's common ground that a large proportion of the commodities underlying these transactions were transferred to the ownership of 2014-1 and then on to State Street Bank as trustee for the note holders. And finally, the claimant's witness, Mr. Zueck, and their expert, Mr. Walk, yesterday accepted that from Samir's perspective, this was a working capital financing. The claimants go through contortions to deny the obvious to this tribunal. Carlyle was financing Samir's inventory and trying to make a profit doing that, essentially via a commodity price arbitrage. That doesn't make it any the less a commodity financing. And you will recall, Mr. Zueck told you, he attended meetings with the Office d'Échange in Morocco. And what they were told, what the Office d'Échange were told by Carlyle and Samir was that this was an inventory financing. Now, if you answer that second question in the negative, have they established all of the things? And we say you must establish that. Then you have to decline jurisdiction over all of the claimant's entities, with perhaps the exception of CCM. CCM would be the only thing that could survive that. And then the third question, which is there, then is has CCM satisfied you as a matter of fact and law that it controlled the commodities and put options which form the claimant's alleged investment within the meaning given to that term control in the FTA? We say it clearly hasn't. I'll say more about that shortly, but it bears recalling that even Mr. Walk has never stated that he disagrees with Mr. Taylor's conclusion that there was no control from an accounting perspective. Mr. Walk has never stated that CCM did in fact control the commodities and the put rights, or even Q1 or 2014-1 or 2015-1 from an accounting perspective. And that omission in his evidence, even when he was given ample prompt to say it yesterday, is telling. And if you answer that third question in the negative, as you must, then you must also decline jurisdiction over CCM's claim. Now, members of the tribunal, the claimants know they haven't met their jurisdictional burden. That's why you got the misconceived advocacy piece in the opening submissions, where Mr. Ordway effectively asked you to find jurisdiction because otherwise no one else will hear their case and Morocco will get away with it. What precisely, we're not sure. But firstly, if that were the test for jurisdiction, we don't need investment treaties anymore. And we don't need investor and investment requirements. We don't need nationality requirements. You can just show up before any tribunal and say, I know I don't fall within your jurisdiction. I know I haven't fulfilled any of the requirements, but please hear me on the merits, because otherwise I haven't got another court to go to. But in addition, it rather seeks to presume the merits of the case, which are at best far from clear, and you certainly can't form any view on at this stage. We've obviously not said anything about the merits yet. We've not filed a counter memorial, but the claimants haven't even come close to a prima facie showing of any wrongdoing by Morocco. I mean, in essence, their case on the merits amounts to an assertion that some executives at Samir told them, so hearsay to start off with, that the Moroccan government had taken some of the commodities in Samir's tanks and taken some of the cash in its accounts. And that's the same Samir and the same Samir executives that in New York, Mr. Zueck and his colleagues were openly calling fraudsters. They were forthrightly telling the New York Supreme Court in sworn depositions and their lawyers in legal submissions that Samir had lied to them and deceived them. So take a step back. Samir is not a Moroccan state-owned company. It is a Saudi privately owned company. It was a company that, by all accounts, was in dire financial straits when Carlyle approached it. It was desperate for funds and willing to enter into, it seems, any arrangements to help its liquidity position. You saw that with the various things it was doing, financings and inventory financings and all sorts. It was also willing to enter into multiple overlapping financing arrangements, pledging its inventory to one bank whilst at the same time trading commodities with others. And as I said, on the claimant's own account, it was repeatedly lying to the claimant over a long period of time and refining its commodities without permission. That's long before any expropriation. And just as an aside, as a matter of public record, there is another pending case against Samir before the English court where a BP entity is suing Samir for conspiracy to defraud. You can find it in a simple online search. Now, when the chickens came home to roost and Samir collapsed in August 2015, it appears, as part of what the claimants have characterized in the US proceedings as its fraud, some of the people at Samir appear to have told the claimants that they only did the things that they did because the government of Morocco forced them to. But there is not, and this is important, there is not a single piece of evidence whatsoever on the record, other than the hearsay say-so of Samir, that points towards the government of Morocco having any responsibility for or role in Samir's actions. The Kingdom of Morocco is being dragged into what in truth is the claimant's complaint about being defrauded by their commercial counterparty. That's the way they put their case in New York. And it is notable that that case was begun a year before this. That's a much earlier case. So their first port of call was to say, this is a commercial fraud against us. And then it goes badly. So they start a treaty case against the state. It's not on. If ever this case were to reach the merits, I would show you the utter unreality of the case and the utter incredibility of it in the circumstances of what they've been saying. And we say that having failed to recoup for their failed transactions, they took these risky transactions with Samir and it went bad for them. They failed to get any recovery from Samir in Morocco. They failed to get any recovery from their excess insurers in New York, and they're now trying to make the Moroccan taxpayer bear the brunt for their risky transactions. And we say this is a transparently self-serving and hopeless claim that fails on jurisdiction, and you must reject it now. Now, let me begin then with these jurisdictional objections with the standing objection, objection 3. I'm going to try quickly to address, as I go along, the points made by Mr. Ordway in opening, as well as the tribunal's helpful questions. And I'll do it in 3 parts. Firstly, I'm going to address you on the proper interpretation of FTA Article 1015.1 using Article 31.1 of the VCLT. So just proper interpretation, not what we say, what the US says. I'll deal with that separately. Secondly, I'll come on to that, the force and effect of the shared agreement by the two treaty parties, the United States of America and the Kingdom of Morocco, under 31.3 of the Vienna Convention, and explain why that mandates that the interpretation of the Kingdom of that article be accepted in preference to that of the claimant's proposal. And thirdly, I will address the implications of that analysis for the claimant's case. So starting with proper interpretation, Article 31. And the first point to make is that it's very important that you understand that the claimants are operating under a fundamental misapprehension and misinterpretation of the decisions of the International Court in Barcelona Traction and Diallo. On Wednesday, Mr. Ordway said that the ICJ in those cases said that Barcelona Traction did not apply in the investment treaty context. And he relied on an excerpt from Professor Schroer's report in that regard, but that is just plain wrong. What the ICJ held is that the starting point in international law is the rule in Barcelona Traction, but that states can contract out of that general rule of international law if they wish to do so. And if they want to do that, they have to make it clear by treaty language. The mere fact that there is a treaty on its own doesn't contract out of an important rule of customary international law. And that's what the ICJ held in the Elsie case that I showed you in opening. And indeed, you can see the position reflected in the claimant's authority that they put in earlier this week, Cube Infrastructure, paragraph 178, which we'll bring up on the slide. And this is an ECT case, so it's a slightly different context, but the point is there. And where one can be misled if one isn't alive to the point is, yes, many investment treaties do expressly contract out of the Barcelona Traction rule. But this FTA, in common with much of the other US FTAs, the NAFTA and various other, in common with long-standing US treaty practice, does not contract out of Barcelona Traction. Now, there are two propositions here. There's a positive and a negative. Firstly, there is no positive contracting out like you find in some other treaties. But secondly, there is also the other aspect that there is a clear statement here. It's clear in the drafting of this treaty that they are expressly preserving Barcelona Traction. It goes beyond merely not contracting out of it. And that's not just what Morocco says or what the US says. It's what every single treaty party that has opined on this treaty language over the last 30 years has said. The US, Canada, Mexico, Guatemala, Korea, Morocco. We've put it on the slide, just the cases. I obviously don't have time to take you through them all. The submissions are public, every single one. And I'll return to that consistent history in due course, because that's also important, dealing with Mr. Ordway's point about the poor claimants who didn't understand that this is what the treaty meant. Nobody's ever said it before. But I think it's also very important for you, members of the tribunal, to understand what drives this consensus. What's the policy rationale for why the states have preserved Barcelona Traction in this way, in these clauses? And the answer, and we set it out a bit more length in our reply on jurisdiction, the answer is that there is a delicate balance between various provisions in Part 10 of the FTA. And the policy priority that they reflect is that where a loss is suffered in the first instance by a company, care must be taken not to allow a shareholder to recover those losses via an indirect claim and thereby prejudice other stakeholders and creditors of the company. And there's I just give you a reference to CL16 Mondev in the US, paragraph 86. That's effectively what that tribunal said. Now, in addition to seeking to denude the words on its own behalf in 1015(1)(a) of any meaning, the major flaw in the claimant's analysis is that they simply ignore the requirement of Article 31(1) of the Vienna Convention that treaty provisions must be interpreted in their context. And that means, in particular, in the context of the rest of the treaty. And as I set out in opening, paragraphs A and B of FTA 1015(1) do different things. The first allows the claimant to claim on its own behalf for direct losses it has suffered. The second, B, allows the claimant to claim on behalf of a host state incorporated company for losses suffered by that company. And we've put the language again on the slide, but you'll be familiar with it now. But I hope you'll also recall from my opening that there is another very important provision at play here, in the light of which these provisions have to be interpreted, and that is Article 1025(2). We'll bring that up on the slide. And that provides that where the claim is brought under 1015(1)(b), so on behalf of the company, any amounts recovered have to be paid directly to that host state company, thereby expressly preserving rights of creditors and other stakeholders. And that concern to protect the right of stakeholders is further affirmed by subparagraph C on the slide. The award shall provide that it is made without prejudice to any right that any person may have in the relief under the applicable domestic law. It's just making absolutely crystal clear that it's preserving the rights of the interested parties, creditors, and stakeholders in the company. Now, if the claimants are right, and indirect losses can be claimed under paragraph A, then Article 1025(2) loses much, if not all, of its utility. Claimants in cases under the FTA could simply circumvent Article 1025(2) by bringing claims for indirect losses under paragraph A for precisely the same direct losses that could be claimed by the enterprise under paragraph B. It's a really important point. They can simply get around this, frustrate the whole purpose of the treaty parties. And that was precisely the concern that animated the Bilcon Tribunal, which in January 2019 rendered its award, and which included, as you'll have seen, Judge Simmer. And we've put the passage on the screen, paragraph 388, and they refer to the warning of the Mondev Tribunal that I referred to earlier, and explain this point, that you can't allow that circumvention. Now, it's true to say that the majority in CAPES reached a different conclusion on the relationship between the equivalent DR-CAFTA provisions. The majority held that indirect claims could be brought under paragraph A. That was obviously in slightly different circumstances, because in particular there was no submission in that case by the United States or any of the other DR-CAFTA treaty parties. And as we'll see later, the CAPES majority very clearly indicated, in fact we'll bring it up on the screen now, that had such submissions been made and an Article 31(3) argument formed, it would have come to a different conclusion. You can see that also in paragraph 156, which we'll put on the next slide. It says there, in the case of DR-CAFTA, unlike NAFTA, addressed by the Clayton Tribunal, there's not yet been any unanimous expression of views about the scope of the implications of the identical provision we're talking about. Clayton is BILCON, just for clarity. They call it Clayton, we call it BILCON. They're the different entities. Now, on the primary interpretation of the equivalent language of 1015(1)(a), we are with the US submission. It is, I'm afraid, just wrong. The majority got it wrong. When confronted with the language, and particularly when confronted with the equivalent of Article 1025(2), which I just drew your attention to, and the policy underpinning it, the majority ducked the question. The only analysis really of the issue appears in a footnote in 142, which we've put on the slide. In short, the CAPA's majority seem to be saying, well, the claimant's claim will be limited to its own losses, so that's okay. But that completely misses the point. If the claimant is the sole shareholder of a host state enterprise that has its asset expropriated, it will be claiming for 100% of the loss. Now, that's obviously fine for the shareholder, but what about the creditors and the other interested parties of the company? They get left out in the cold. That's why Article 1025(2) applies. If it's a direct claim under 1015(1)(a), that issue doesn't arise because the investor can't claim the company's loss. It can only claim a direct loss, as the examples given by the US, the failure of a dividend or something like that, or if the investor's shares in the host state company are expropriated, for example. To allow the claimant's interpretation is upending that careful treaty structure and the protections the treaty parties were careful to include. And a related concern of the treaty parties is the spectre of double recovery. And we can see the treaty parties attempted to avoid that in FTA Article 1017(2)(b), which we've put on the slide. The claimants waive their right to initiate or continue before any administrative tribunal or court under the law of either party or other dispute settlement procedures, any proceeding with respect to any measure alleged to constitute a breach referred to on 1015. So if a shareholder wants to bring a claim under 1015(1)(b) on behalf of its company, it has to provide a waiver for both itself and its company, with the result that the controlling shareholder in the company cannot pursue remedies in different fora with respect to the same loss. And again, that provision on the claimant's interpretation is rendered substantially ineffective. If shareholders can bring claims under paragraph A for the losses of a company, whilst leaving the company free to pursue domestic proceedings with respect to the same loss, that would completely drive a coach and horses through this. And the majority in CAPA's analysis on this point is, I'm afraid, not remotely convincing. We've put it on the slide, paragraph 140. And whilst it frankly acknowledges that its approach to the equivalent provision creates some serious policy problems, it washes its hands of it, so it's not our problem. And then in the following paragraph, it goes on to say that if the parties to DR-CAFTA wanted to avoid this problem, then they would have expressly said that any indirect claim by a shareholder under paragraph A for the losses of a company should also include a waiver for the company. But I'm afraid that's just a failure of analysis. There was no need to make provision for double waivers because claims for company losses cannot be brought under paragraph A. So they only get to that analysis by misinterpreting provision A. So what we see is that the FTA, Article 1015, 1025, 1017, is a sophisticated mechanism to prevent multiplicity of claims, double recovery, and prejudice to the rights of company stakeholders, and to maintain and preserve the general rule of international law long established in Barcelona Traction. If the Kappa's majority is right, all that can be swept aside simply by a shareholder bringing a claim under 1015(1)(a) for the losses of the company. And with the greatest respect to the majority, Professor Douglas, in his characteristic erudite exposition, destroys their analysis. In his persuasive dissent in Kappa's, confirming the unanimous tribunal interpretation and reasoning in Bilcon, the tribunal, as I say, including a former judge of the International Court, Professor Douglas makes the same point we do now, which we've put on the slide. Paragraphs 7 and 9. And that's the point I've just been making. And he then went to point out in the following paragraph that the majority's analysis of the effet utile principle was also wrong. And that analysis, which is at paragraphs 145 to 149 of the majority opinion, was couched in terms of whether the claimant's interpretation undermined the equivalent of subparagraph B. But that is, of course, the wrong question. The right question was whether the claimant's interpretation undermined the equivalent of articles 1025(2) and 1017(2)(b, and they plainly did. Two further points on the interpretation of FTA article 1015(1). The first is in response to Mr. Ordway's point that para 1015(1)(a) must permit claims for indirect losses because FTA article 1027 provides that an investment can be held indirectly. Well, if we return to article 1015(1) on our interpretation, it gives a prospective claimant two options. It can bring a claim for direct losses under A, or claim indirect losses on behalf of a company under B, provided, of course, that there is a host state enterprise in the latter case. That same scheme is found in the definition of investment in article 1027. Under the definition, an investment can be held directly, which enables paragraph A of the claim, and it can be held indirectly, enabling a claim under paragraph B. So contrary to Mr. Ordway's suggestion, a prohibition on claiming indirect losses in the context of 1015(a) does not render the capacity for indirectly held investments a nullity. In fact, to the contrary, it gives it meaning by allowing the claimant to use an indirectly held investment to bring a derivative claim under paragraph B. And my second point is why the analysis that I've just explained to you is important in the context of this case, where there is no host state company. And the answer is that paragraph A of 1015(1) is the rule and B is the exception. And we explain that in our reply, paragraphs 264 to 279. The treaty parties in article 1015(1) set out a position whereby indirect losses could only be claimed when the limited situation in which paragraph B was engaged, a derivative claim on behalf of an enterprise. And where paragraph B was engaged and invoked, the claimants were careful to condition that paragraph by reference to principles in 1025(2) and 1017(2)(b). No multiplicity of claims, no double recovery, etc. Those concerns which we've put on the slide, they are evergreen. There is no principled reason why the treaty parties would have expected these priorities to apply where a claimant brings a claim for losses suffered by a host state company, but not where the claim is brought for losses suffered by a Cayman Islands incorporated company. And they showed this by expressly not including such companies in the exception of paragraph B, thereby excluding their losses from being the subject of a claim. There is no principled reason why the United States and Morocco would permit a claimant that situates the operating parts of its corporate structure in a tax-friendly third jurisdiction like Cayman to be in a better position than a claimant that either made its investment directly or incorporated a local host state enterprise. Indeed, such a situation would incentivize structures like the one in the present case, which are designed to result in the minimization of tax revenue for both home state and host state. That would be an extraordinary interpretation to find that that's what these treaty parties intended, or any treaty parties agreed to. And more to the point, the current case and its facts demonstrate how unsavory such a situation can become. The claimants are before you arguing that they must be compensated for Morocco's alleged expropriation of the commodities. At the same time, Q1 2014-1 and 2015-1, the real direct asset holders in the Cayman Islands are arguing in New York that their insurers must pay out because Samir defrauded them and stole the exact same commodities. And that, moreover, is taking place in circumstances where those same entities have already failed to recover that loss from Samir's administrator in the Casablanca Commercial Court, which found they had no proprietary interest. Now, in opening, Mr. Ordway said that two other cases, Waste Management and GAMI, also dealt with the issue that's before you. Well, he's wrong, they didn't. They both dealt with different points. GAMI was a case where the US claimant owned a minority shareholding in a Mexican company called GAM. And Mexico expropriated certain mills owned by GAM, and the claimant then brought a claim under Article 1116, for the reduction in value of its shareholding. So GAMI was claiming what it characterizes as a direct loss, and you can see that at paragraph 23, which you have on the slide. And the tribunal was focused on the question of whether the claimant could claim under Article 1116 in respect of a loss that resulted when the value of the shareholding was reduced by Mexico's acts. But that was a direct shareholding. In my submission, that's very different to the present case, which involves third state intermediaries and two levels before you get anywhere near the US. But even if you thought that this outlier decision in GAMI was of any particular relevance or interest, you'd have to bear in mind that this is a very early case. The decision is from January 2004, the award. And it was before the consensus position in relation to the NAFTA, where all the other treaty parties joined the US in expressing the view, the clear view, which has been consistent ever since, that that 1116 means exactly what we say 1015A means and what the US told you in its own submissions. So we say it's highly unlikely that the GAMI Tribunal would decide that case the same way today, even if it is dealing with the same issue. Waste management is not even remotely dealing with the same point. The point in waste management was whether a US claimant can bring a claim as the indirect shareholder of a Mexican company where the intermediate company wasn't a US national. It wasn't about whether indirect shareholders can claim at all. It was about whether indirect shareholders are allowed to claim under that treaty, not about whether an indirect shareholder has standing to claim indirect losses. So it's completely irrelevant. Mr. Ordway also referred to some other cases as being relevant on this point. The Electronica Circular case wasn't an investor state case, as I think Mr. Ordway wrongly spoke in opening, but an interstate case, of course, under a completely different treaty. Mira and Serbia, also, that's under a Cyprus-Serbia BIT. It's got nothing to do with NAFTA or any of the US FTAs. And Cube investment in Spain, ditto, that's an Energy Charter Treaty case, as we saw. It's not a US FTA case or a NAFTA case. And the critical point, obviously, is in none of those cases was the tribunal's jurisdictional mandate constrained by wording similar to FTA Article 1015.1. So they're just not relevant to the case at hand for those points. Now, to conclude on this point, members of the tribunal, what I've tried to demonstrate is that the orthodox analysis under 1015.1, applying Article 31.1, confirms clearly that the interpretation we give, that you can only claim for direct losses, you can't claim for indirect losses under 1015(1)A, is right. And with that, I'll move on to 31.3 of the Vienna Convention, the shared agreement of the USA and Morocco and its implications. Now, given what I've just said to you, we don't need this on my primary case to prevail on this issue because we win on as a matter of interpretation. But in any event, there is a separate reason why we win, and on any view, it should give the tribunal very significant comfort that the treaty parties' interpretation of 1015(1)A is to be preferred. Now, VCLT 31.3A provides that in interpreting a treaty, the interpreter must take into account any subsequent agreement between the parties regarding the interpretation of the treaty or the application of its provisions. Any. And as we pointed out, and the USA pointed out in its submissions, the ILC in its commentary noted that such an agreement represents an authentic interpretation by the parties which must be read into the treaty for the purposes of its interpretation. And the claimants also seek to rely on the same commentary. It's been approved, that aspect of the commentary was approved by the Methanex and US Tribunal, paragraph 19, which we've put on the next slide. And as that tribunal refers to, it's been cited with approval by the ICJ in a case as well. So what is the effect of an agreement between the two treaty parties once it's deemed to exist? And we've put in for you Professor Gazzini's analysis in his treatise on the interpretation of international investment treaties, because that's, in my submission, very instructive. And I would urge you to read the whole of it in your own time, to the extent you haven't already. It's not a long piece, but at page 188, which we've put on the slide, he explains that with reference to the ILC's commentary and the approval of that commentary by Methanex and the ICJ, since subsequent agreements are part of the treaty, the interpreter must respect them, not only take them into account. Even more, the interpreter is expected to examine them from the very beginning of the interpretative process. I'll leave you to read the rest of that. But the short point is, when you're sitting down to interpret 1015(1), you have to do so from the starting position that the US and Morocco have agreed what this provision means, and you have to treat that view as forming part of the FTA. You don't do what we're doing now, in a sense, which is starting with the ordinary meaning and then come to this part. And Professor Gazzini's next point goes to the discretion that you have. And as I said in opening, you're not bound completely by Morocco's agreement with the United States, but nevertheless, you would have to give it very significant weight. And indeed, we are not aware of a single case in which an international court or tribunal has departed from a 31.3A agreement once it's been found to exist. And certainly the claimants haven't shown you one. And Professor Gazzini expresses the position as follows. We'll put it up on the screen perhaps. Here, that you're legally bound, the authentic interpretation, and that you have to adopt the interpretation that emerges from the analysis of the treaty. And it follows, members of the tribunal, that providing you don't see the text of the FTA as being completely irreconcilable with the USA and Morocco's shared agreement, you really ought to give it effect. And even if you did consider that it was completely irreconcilable, even then it wouldn't follow necessarily that the text of the treaty is to be given priority over the lex posterior and the lex specialis of the agreement. And a good illustration of that is, in fact, the majority decision in Capes. In that case, the majority disagreed with the Bilcon Tribunal and held that indirect losses could be claimed under the DR-CAFTA equivalent. But that was in circumstances where it expressly found that there was no 31.3A agreement before it. As I've shown you already, it effectively admitted that had such an agreement been before it, its conclusion would have been different. Another point to consider when we're dealing with the effect of such an agreement when it exists, Mr. Wordsworth asked a question in opening or after opening on whether the effect of a 31.3 agreement was purely prospective, that is, taking effect from the time of interpretation onwards. The short and clear answer to that is no. Like all authentic interpretations, an agreement under Article 31.3a is the parties effectively saying this is what the treaty has always meant. It has ex tunc effect. And there's nothing in the case law, the ILC's commentary, or the text of Article 31.3a itself to suggest a prospective effect only. Now we can draw a distinction here between an interpretation of a text which is uncovering the party's original intent, which is what we're doing here, and a different thing, which is an amendment of the text of a treaty, actively seeking to change the text by adding new rights or obligations, and therefore departing from the original intent of the parties. An amendment is only prospective, as Professor Gazzini makes clear in the passage of his relied on by the claimants in their opening, from page 198 of his book, which I think is on the screen now. Now, the confusion that the claimants are under is they seem to think this is talking about agreements to interpret, but this isn't. This is talking about amendments. You can see from the bare words on the page, it's clear that's what he's talking about. And you can also see that from the continuation of his thoughts over the page, which unsurprisingly you weren't shown in opening, but are now on the next slide. Agreed interpretations govern all cases, including pending ones, whereas amendments have only prospective effects. One final point, which arises from a point made by Mr. Ordway in opening, to the effect, well, you shouldn't give effect to a subsequent agreement because it would cause unfairness to his clients on the basis that it's tantamount to modifying a tribunal's jurisdictional mandate after an arbitration is commenced. And he said that was part of the obligation of interpretation in good faith set out in Article 31.1, referred to an extract from Dr. Wiramantri's book. But the short answer is, of course, that the obligation of good faith in Article 31.1 is on the interpreter and not on the state's parties to the treaty. Contrary to what the claimants say, that means that the interpreter must apply, you must apply the Vienna Convention, Article 31, faithfully and give full force and effect in so doing to a subsequent agreement under Article 31.3. That's not to say that all subsequent agreements should be reflexively applied. If it transpired in some way that parties to a treaty had actively conspired for the purpose of shutting out a specific claim in bad faith, then international law might see that as an abuse of right and refuse to give it effect. And that's rather what Dr. Wiramantri had in mind, and when he was referring to what was being contemplated at one stage by the Aguas del Tunare Tribunal. That paragraph 263, which is on the slide. That's what the Aguas del Tunare Tribunal was talking about. And that's not the case here. The US has quite deliberately and quite appropriately expressed no views on the merits of the Kingdom of Morocco's jurisdictional challenge. It has simply set out what its position is on the meaning of the treaty. And in any event, evidence of the strongest kind would be required to prove, which is not even alleged at the moment, that the Kingdom of Morocco and the United States had conspired in bad faith to deprive the claimants of their claim. So that's the effect of an Article 31.3a agreement. The next question, how one is formed, take it quite shortly. First, Mr. Ordway suggested to you that the fact that the parties didn't have recourse to the joint committee procedure under FTA Article 19.2 meant there could be no agreement. Wrong. As the USA said in its submissions, which we agree with, that's just wrong. It's an argument that's been made before with the equivalent procedures under NAFTA and DR-CAFTA, and it's been rejected in every case. The mere presence of FTA Article 19.2 does not mean that the parties precluded themselves from making an Article 31.3a agreement. Indeed, the CAPES Tribunal and the BILCON tribunals both accepted that point. We've put paragraph 156 of CAPES on the slide, which refers back to the BILCON tribunal, again, calling it Clayton. Secondly, Mr. Wordsworth asked whether a joint agreement can be formed between a non-disputing party submission on the one hand and a disputing party submission on the other. Again, the US has expressed its views on that, and the only thing we'd add to it is we're not aware of the point having been decided in any case, but given that an agreement can be expressed informally or in separate documents, there is no reason why it couldn't be shown in that way. After all, Article 31.3a speaks of any agreement, and this is an agreement in formal, publicly available submissions before an international tribunal. And what matters is there a confirmed meeting of the minds? And Professor Gazzini makes precisely that point at page 195 of his treatise, which we've put on the next slide. It seems relatively easy to establish when the concordant views of the parties on the interpretation of a treaty occur almost simultaneously with regard to the same dispute. And he refers to the Methanex. So applying that to this case, first point, Mr. Ordway conceded already, as he had to, that the USA and Morocco are ad idem on this. We're agreed. Put it on the slide. Our position is that that agreement must, at a minimum, very strongly guide the tribunal's interpretation of FTA Article 1015.1, as Article 31.3a requires. The second point to make is that Mr. Ordway's submissions are wrong. Wrong that the agreement between Morocco and the US on the interpretation of Article 1015.1 is an attempt to amend a provision. Wrong that the agreement should somehow be discounted because it is at odds, he says, with the US's historical position. And wrong for the tribunal to take proper account of the agreement would be somehow unfair to the claimants, because it says now it was unaware when the arbitration commenced that that was what the treaty meant. I'll take those points together, and they are perhaps most easily understood simply by the history of the US position, particularly on NAFTA Articles 116 and 117. And the main point is very simple. The US position on that language, in my submission, has been entirely consistent for 3 decades. It is extremely well known. Moreover, as I said earlier, that same position has subsequently been adopted by every state party to a treaty containing this language that has ever had cause to opine on it. Not just the US, but all the others, as I stated earlier. And in no case have those opinions been considered disguised attempts to amend the language of the relevant treaty. And given the history, the period we're talking about, these sophisticated, well-lawyered claimants should have been well aware of how that language is to be interpreted. And no unfairness arises if they weren't. You can't show up and say, I misunderstood what the treaty meant. I didn't know the ECT contains a tax carve-out. And the tribunal say, well, okay, we won't apply that to you then. Now, the US position began in the 1993 Statement of Administrative Action laid before the US House of Representatives when NAFTA was passed. We put that on the slide. Absolutely clear. Direct injury to an investor, an allegation of indirect injury to an investor caused by injury to a firm in the host country owned or controlled by the investor. In their submissions, the claimants accused the US of inconsistency on this score pointing to statements made in Myers and Pope and Talbot. And the problem with the analysis is that in those cases, the US was making submissions on when a claim should be brought under Article 116 or 117. It wasn't addressing the situation where an investment is held indirectly by a third state intermediary. It was addressing cases where the investment is held directly. And that's also the United States understanding of what it was saying there, because if you look at the United States submission in Bilcon, which they referred to earlier, and we've put it on the screen, it cited both of those passages in support of the position that it takes here. So apparently it's not just us who got it wrong, the United States doesn't understand its own submissions. But even if you felt some momentary temptation to try and find some inconsistency in the US position of 20 years ago, there's not even a suggestion that the position has been anything other than completely clear and consistent since at least 2004 and the Thunderbird gaming submission. When the US expressly said that NAFTA Article 1116 reflected the rule in Barcelona Traction and that Article 117 was an exception to that rule. We put it on the slide. Unsurprisingly, in the light of the clear and consistent history, we're not aware of anybody else ever having accused the United States of deviation from its 1993 position. We've put some examples on a slide. I'm not going to go through them, but the consistent practice was noted by the CAPA's majority and by Professor Douglas in his dissent. More to the point, no other party, as far as we're aware, in any treaty case, has ever accused the United States or any of the other 5 states who are parties to treaties with this language of attempting to amend the treaty when opining on the distinction between direct and indirect losses. And it's confirmed by the terms of the FTA itself, as the claimants have pointed out. Article 22.2 of the FTA is the provision that governs amendments. It sets down a process for amending the FTA. Neither the United States nor Morocco have taken any action under that provision. We're talking about interpretation, not amendment. So in the light of that clear and consistent history, it is little wonder that Morocco has the same understanding as the US, the other NAFTA parties, the other parties to all of the US FTA, which contain this language. And when the claim was brought against it, Morocco raised this point immediately in its application for bifurcation, at the earliest possible stage. Its interpretation was then confirmed much later by the US in its submission, resulting in the current Article 31.3 agreement. So the proper interpretation of the language of 1015.1 has been clear in my submission for 30 years. And if the claimants were not properly advised in that regard, that is not Morocco's fault. And certainly no unfairness can be said to arise. Finally, Mr. Ordway attempted to convince you that this is all a problem for the merits, by reference to a number of cases where it was said that the investor wasn't required to prove its loss at the jurisdictional stage, Mikula, Total, Bywater, etc. But those cases are inapposite. We're not asking the claimants to prove their losses at this stage. All that we and the treaty require them to do is to identify for each claimant a qualifying direct loss that is claimed. That is an essential predicate to each of them claiming and having standing to claim under Article 1015.1a. We set that out in our reply, paras 280 to 283, and we can see acknowledged by the CAPA's majority at paragraph 120, which we've put on the slide. Making quite clear this is a jurisdictional question. They have to show that they suffered the direct loss. And as I pointed out in opening, I'm not going to repeat now, the claimants have repeatedly failed to do this. And I made the points in opening about how they initially framed their claim as their commodities, their put rights. And the same happened in opening. It was all about the claimant's commodities, the claimant's put rights. Then we've got these 2 last minute attempts to say that CCM had some direct claim. And in opening, we have this further new claim that because CCM, it said, failed as a result of Morocco's actions, that's a direct loss to CCM. Leaving aside the control and ownership fallacy inherent in that submission, which we've put on the screen, at best what Mr. Ordway has done is identify yet another indirect loss in relation to CCM. On his own case, CCM didn't have direct control over the assets that are the alleged investments. It purportedly had control over Q1 and 2014 one, which, again, on the claimant's own case, owned the commodities and had the direct control. So it's, at best, an indirect. Now, if you're not with me on objection 3, then the claimants have still got to establish the factual basis for jurisdiction. You're accepting now that the claimants may claim for losses which they themselves didn't suffer, but which they say were suffered directly several corporate layers down the chain from any of the claimants by a Cayman entity that contracted with SAMIR. Now, I'll come on to the law in relation to these shortly, but first, the facts are important, and the facts and the factual disputes span almost every aspect of both the corporate and transactional structure of the investments. The parties don't agree as to the nature of the transactions, they don't agree which entity held title to the commodities, and they don't agree which entities were owned and controlled by the claimants. Now, I should have hoped that by now you will be comfortable with the structure of the transactions and the corporate structure, so I'm not going to cover those in any detail. What I want to focus on in the limited time available is some of the important issues that have been clarified by the evidence, and to respond briefly to some of the factual assertions made by the claimants in opening. So firstly, I want to say a couple of words about burden of proof, but very shortly. Secondly, I'm going to explain why, from a factual point of view, the case as presented by the claimants just doesn't withstand scrutiny, and they fail to meet their burden of proof. But worse than that, much of what they assert is deliberately vague and demonstrably wrong. And thirdly, I'll remind you, in the light of the factual position as it stands, that why you can't be satisfied that you have jurisdiction. The burden of proof point, I mean, we've said it out in our submissions so many times, but Mr. Allway raised it again in opening. It is abundantly clear that where you are a claimant under an investment treaty, the burden is on you to satisfy the tribunal that you have met the jurisdictional predicates. Are you an investor? Do you have standing? Did you concretely make the investment? Did you make a contribution? Those sort of points. It is not enough in order to satisfy those cardinal questions simply to assert the answers. You have to prove them by reference to evidence and the law. And the United States agrees with us on this. They make the same point at paragraph 12 of their submission, which I think we've got on a slide. The only exception to that rule applies if a particular jurisdictional objection was to arise from a positive factual objection by us. So if we alleged that the claimant's claims were an abusive process, or that the claimants had engaged in illegality, then we'd have the burden to prove that primarily. But that's not where we are here. And that point is just reinforced by the PACRIM and El Salvador Tribunal, which the claimants mistakenly rely on, even in opening. We've put paragraph 211 on the slide. The claimant has to prove that the tribunal has jurisdiction. If there are positive objections, i.e. illegality, abusive process, that sort of thing, the burden lies on the party presenting the objections. We don't make any of those objections. We say they haven't made out their case that they meet the predicates for jurisdiction. And we set out in our reply a matrix showing how tribunals have dealt with the objections we now make from a burden of proof perspective. And in every single case, the burden has been on the claimant. And we've put it on the slide just for ease of access, but I'm not going to go through it. Now, what do we know now in the light of the burden of proof and the evidence? Big picture, some fairly obvious points when you understand the structure of the operation. We bring up the structure chart on the slide. First point, we know who put the money in. The Maryland Pension Fund and the third-party foreign investors, the note holders. They're the ones who put the money in. It's common ground, as far as we understand it, that all the money came through them. And those third-party investors are not claimants in this claim. And we know also who lost the money that they'd invested through this structure. Same third-party investors. Mr. Zuak made that crystal clear during his direct examination. Day 2, page 20, in relation to the Maryland Pension Fund. You will have understood that, no doubt, it's obvious, but it's also very important because the tribunal knows as well that neither of those third-party investors who lost their money are sitting in the structures anymore. They were taken out. And to save time, I'm not going to go into the protected information to deal with that point any further. But in other words, at August 2015, at the date of the alleged treaty breaches, the claimants above the onshore feeder had no stake in these investments at all. And you, the tribunal, must determine whether the evidence establishes that each of the claimants was an investor as at the 7th of August 2015, the alleged expropriation date. And we say it's immediately obvious that most, if not all, of the entities who were claimants simply couldn't have been investors at that time. Now you can go back, we've put some quotes on the slide now of the case as it was advanced by the claimant in the memorial and the observations on bifurcation. I'm not going to repeat it. We dealt with it in opening, and we'll go through to that now. No, past. And we go past that slide. It won't have escaped your attention that in the original structure, they were presenting themselves as the owner of the economic interest in these fund structures. And they went further and presented the economic stakes through LP interest or participating shares as giving their entities ownership or control of the investments. And the original case rapidly unraveled for the very simple reason that the economic stakes were acquired long after the alleged investment and the alleged expropriation. And moving on, next slide, please. Having had to acknowledge that their case based on economic interest was untenable, we've now seen a remarkable change in tack. And this is apparent from the way things were presented to you in oral opening. Now, what Mr. Ordway was telling you in oral opening was that the LP interest, the limited partnership interest in the onshore feeder, is entirely irrelevant. Mr. Ordway will need to explain to you why, if that was so, his client's original case was that the LP interest in the onshore feeder was at the heart of their case on ownership and control. What you're now being told is that the general partner, which is the entity with the power to operate the onshore feeder, but no economic interest, is the true owner. And the problem with that change of tack, whereby ownership and control sits not with the economic interest, but with the management entity, is that it renders that case incoherent. Let me show you this on the chart. In this slide, I've circled for the tribunal's interest where the entity with the management shares or the full shareholding sits in the structure. There's something pretty striking about that. As the tribunal can see, the management entity for Q1, its equivalent of a general partner, if you like, is the management shareholder. That's an entity in relation to which the claimants have refused to give any evidence at all. They won't even tell you who it is. And as you can see, the managing entity for 2014 one is Appleby Trust, not a claimant. If it's those management entities that own or control 2014 one and Q1, then obviously that's a dead end for the claimants. They clearly do not own or control them. So what the claimants have to do in order to maintain their artifice is contradict themselves. And you saw that in their opening. We show that on the next slide. So what Mr. Ordway said in opening is on the slide. It's all about the participating shares. As far as Q1's concerned, the management is irrelevant. It's all about who owns the participation rights, the economic interest. That's what's relevant for ownership. And there is an irreducible inconsistency arising out of that, which we say is fatal to their case. Either ownership or control set with the economic interest, i.e. Maryland Pension Fund and the note holders, who are not before this tribunal, or ownership and control sits with the corporate entity, which owns the managing shares, but then Q1 isn't owned by a claimant, and neither is 2014 one or 2015 one. Rather than engaging with those inconsistencies, you're presented again with a series of generalizations. And I just don't have time to take you through them, I'm afraid, but we've put the quotes on slides. They just refer to themselves the whole time as claimants. And Mr. Zuek kept on that. I kept on saying, oh, I viewed it all holistically in a sort of set piece mantra that he wanted to repeat. I reviewed it all holistically. I don't really mind which entity it is. Now that's all self-evidently designed to support a case that you don't need to worry about which entity did what or the delineations between entities. But that's completely wrong. What the claimants seem to say, and I think what they get wrong here is they say you don't have to worry about whether a particular company was an investor with an investment. Ignore the unhelpful detail, look at this in the round, and they say because there's this thing called unity of investment. But that theory goes nowhere here and simply reflects a confusion. Nobody disputes that there is a principle of unity of investment in international law. What the claimants are talking about seemingly is a new theory that we've never heard of called unity of investor. But there is no such principle for good reason. Now, the accounting reality, Mr. President, you raised the interesting question about consolidation. The accounts are in the record. We'll make submissions about that later. It's pretty clear the change between 2015 and 2017. In 2015, none of Q1, 2014 one or 2015 one, or in fact, any part of the master feeder structure was consolidated in Carlyle Group accounts, including the US onshore feeder. In 2017, that's partly changed in relation to 2014 one and 2015 one, but that's because the Carlyle Group then had an interest in them. But even then in 2017, the onshore feeder structure, including Q1, was not consolidated. And that just confirms the point we've been making from the outset. They were not the claimant's investments as at the 7th of August 2015. As at that date, they were investments of third parties who are not with us in this virtual hearing room, and for good reason, because they are not valid investors' claimants. And you are being asked to allow, through a sleight of hand, a group of entities that never had any proprietary interest in any of these assets in Morocco to bring a claim against the kingdom. Now, the accounting principles, we don't say that accounting principles as to control bind the tribunal, or that the term control in the FTA is a reference to the accounting rules. That's never been our case. We've never said that. All we are saying is accountants have spent decades considering complex structures, such as fund management structures, to try and extract from those structures the true economic position. The accountancy rules want to understand, when looking at control, who is the true economic controller of a business. And they do that through a complex factual inquiry. And we say that's precisely how control should be approached from the FTA's perspective as well. And Mr. Walk, it is striking, recognized that identifying the economic controlling entity from an accounting point of view involves a factual inquiry in exactly the same way as the United States articulated in their own submissions as the proper interpretation of the FTA. We've put them on the slide. There's the question and answer that I put to Mr. Walk, and I effectively quoted what the US said as to the way to approach the determination of control under the FTA. Now, let's assume for an instant that the claimants can find a way around the fundamental problem with their lack of any economic stake or ownership in Q1 or 2014 one. The next question for the tribunal is, what commodities did they actually own or control indirectly? The first point is, as I believe you understand, for most, if not all of the transactions, the ownership interest in the commodities passed from Samir to 2014 one. We can show that on the screen. We've addressed you in detail about that. I'm not going to spend any more detail on it. They sought to gloss over the issue in opening. and say that that's not relevant. It's anything but irrelevant. It's patently obvious that any assets that are transferred to 2014-1 or 2015-1 entities and onwards to the note holders isn't an asset of the claimants at the alleged expropriation date. They don't own it. Their only claim is then through a contractual asset management agreement with CCM. We've put on the slide the Mr. Zuek's answer to Professor Noan's question on that basis. And the tribunal, you will understand this. This isn't control in an economic sense as required by the treaty. It's simply a contractual delegation. And in oral opening, the claimant's case was replete with hyperbole as to the extent of CCM's alleged control. Controlled every aspect. It's controlled incontestable, all encompassing, etc. We also heard that the claimant companies had no employees. Though, of course, they do have directors, as Mr. Ordway acknowledged with some reluctance. They're separate legal entities. In their written pleadings, the claimants presented Q1 2014-1 and 2015-1 as pass-through companies with nominal directors who did as they were told. But you heard Mr. Zuek yesterday when I asked him specifically about the directors of Q1 and the director of 2014-1, whether they were nominal directors. He said he wouldn't classify it that way. You heard from Mr. Walk that these companies had their own accounts and bookkeeping, none of which has incidentally been produced to us or to you, members of the tribunal. So what's become crystal clear over the last couple of days is that far from the way the claimants wish to present it, these were independent companies with separate legal personality, their own directors, and their own books and records. And they simply delegated some powers to CCM within narrow contractual bounds. Indeed, the claimants went so far as to suggest that CCM's control was so extensive that it could transfer title to the commodities at its sole and absolute discretion, regardless of whether the commodities had been transferred to the state, the trustee. Well, I rather doubt State Street Bank's lawyers would have agreed with Mr. Ordway if they'd been in the room when he said that. In any case, though, under cross-examination, the claimant's case unravelled. Mr. Zuek repeatedly acknowledged that CCM's power was constrained by the terms of the contracts. He had to. Ultimately, it was subject to the decisions of the directors of the companies or partners in the partnerships who had entered into the management contracts and who could amend them or end them whenever they wanted. The true control sat with the corporate entities and their governance structures, and that's clear from the terms of the management agreements themselves, which I put on the slide. Now, in the light of what I've just explained, in my submission, the tribunal must conclude that it has no jurisdiction over any claim arising out of commodities where the proprietary interest was held by the 2014-1 and 2015-1 structures. So if we show that on the slide, the 2014-1, 2015-1 structures leave. That leaves the claimant with only one possible route to establish even indirect ownership or control, and that's the onshore feeder. And in order to satisfy you that the onshore feeder indirectly owned or controlled Q1, you will need to be satisfied, first, that the onshore feeder, as opposed to somebody else in some other structure, owned and controlled Q1. And the claimant's failure to provide any evidence as to the identity of the management shareholder of Q1, we say is fatal at that step. All Mr. Ordway had to say about this on Wednesday was that we were unduly fixated by these management shares, and it's the economic interest which we should be paying attention to. And I've already explained the internal contradiction on that. But if those management shares are so unimportant, why haven't Carlyle confidently disclosed who held them and explained by reference to legal principle why they're irrelevant? There's an obvious inference that if you were aware of that information, it's unhelpful to their case. Secondly, you need to be satisfied that the onshore feeder in fact contributed funds to Q1 which were used for the acquisition of some of the commodities at issue in this case. And as we explained in opening, the only evidence to that effect from the claimants is two sets of accounts as at the 31st of December 2015. And those accounts tell you nothing about the position in August 2015. Mr. Zuek accepted that. Can we put it on the? And as an aside, it is obviously useless to know that a particular entity held any particular interest in Q1 by 31 December 2015, because as we've seen, the sleeve transactions meant that the landscape was changing rapidly over the course of 2015. We put that in our summary table so you can see it. So what was true about Q1's holdings on the 31st of December 2015 almost certainly wasn't true in July or August 2015. Now, in direct examination, Mr. Zueck simply asserted in completely new evidence that the funds had been contributed by the onshore feeder at some time in the spring or early summer of 2015. Now, that new evidence, not mentioned anywhere in his witness statement, in his 3 witness statements so far in this proceeding, that new evidence was clearly prepared in advance because it was foreshadowed by Mr. Ordway on Wednesday in opening. Clearly, the claimants realized they had a problem on this front and asked Mr. Zueck to say it was all made in time. Why he didn't bother to say that at any previous point in any witness statement is a matter for him. But the problem is, even with that new assertion, there's no evidential support.
Mr. President.
All that.
Ordway.
Yes, excuse me, Mr. President. I merely want to point out that I believe that Mr. Harris has been going on far in excess of the time that was allotted. I don't seek to interrupt Mr. Harris, as I was forced to, though, because, but really, I do think we had limits. We agreed on certain limits.
Let me get a time check from the secretary, Mr. Ordway.
No, if I may, there was an hour and a half allotted for the respondent's closing as well as for the claimant's closing, and Mr. Harris has been speaking for an hour and 13 minutes.
Oh, my apologies. My understanding in looking at the schedule was that he had exceeded, but it was a change in the schedule. My apologies. Please go on. Thank you.
You have the same problems I have with the US, London, Washington, and Madrid time, and we get confused. But I think he has still like more than a quarter of an hour to go.
Yes.
Very good.
I'm very grateful.
Sorry for the interruption, Mr. Harris, but you have the floor back.
Thank you. I was just talking about the Mr. Zueck's new assertion that the funds were transferred in spring or summer 2015, as vague as that is, and the fact that there's no evidence to support that. And the point there is, of course, that all the claimants had to do was to produce bank statements showing the relevant transfers. We've repeatedly asked for them. And you've seen that where it's useful to them, they have produced the transfers. So, for example, where they're trying to show that Q1 sent some money to 2014 one, for the sleeve transactions, where they're trying to say, well, we did contribute something before the letter of credit went out. They produce it then, but they haven't produced it for these. And that failure, in the light of our repeated question, is very telling. And we say that you must draw the inference that they cannot show in bank statements what they assert about the fund flows. Hence, over 4 rounds of written submission, 3 witness statements, and all the submissions in this case, they haven't produced them. And they haven't said that they don't have them, and they haven't said that they don't exist even. And that makes the inference all the stronger. Now, the third thing you'd need to be satisfied of is that the evidence shows that Q1, in fact, held on its own account commodities. And during the hearing, Mr. Zueck, who, let's not forget, told us that he was responsible for compliance at CCM, he's the chief compliance officer, asserted that Q1 didn't need to have any audited financials because one could simply look through the accounts of Q1 and roll them up into the accounts of the master fund. But the claimant's own expert, Mr. Walk, explained that that couldn't be right. Q1 as a legal entity must have had its own documents, including its own internal balance sheets. We've got that on the slide. And the claimant's failure to produce those documents, balance sheets and internal evidence from Q1 as of August 2015, means again that you can't be satisfied that Q1 owned any of the commodities as at that date. Fourthly, you need to be satisfied that any such interest in the commodities was not passed through to 2014-1 or 2015-1 through sleeve transactions. And as we've made clear in opening, and I don't understand that there's a dispute about it, every letter of credit issued for every transaction in this case was issued by 2014-1. Mr. Zurek acknowledged it, albeit trying to caveat it through his mantra of holistic transactions. And indeed, as was observed during cross-examination, the letters of credit list 2014-1 as the entity to whom the proprietary interest vests once the letter of credit is drawn upon. And we've gone through and we've looked at the language, and in relation to every letter of credit where the information about a consignor has been made available, which is all but two, the consignor is 2014-1. For the remaining two transactions, Samir 1011 and 1021, the letter of credit's in a different format, and it looks as if the terms regarding consignor would have been attached, but they haven't been provided. We haven't got them. But there's no reason to think that they wouldn't follow the same course. And importantly, the consignor is 2014-1, even in relation to the transactions which the claimants say were funded by Q1. That's Samir 1014, 1015, and 1016. So that puts beyond doubt what we said in the opening. It was 2014-1, not Q1, which directly funded all of these transactions. And it was 2014-1, not Q1, which took title to the commodities, which were the subject of the transactions. And the fact is that you simply cannot be satisfied on the balance of probabilities that the onshore feeder owned any commodities, even indirectly through Q1. The claimants had to prove that. They have all the evidence. It's not a situation where they can say, well, we don't have the evidence, Morocco's got it, and we haven't been able to get it from them. It's their evidence, and they haven't produced it, and they haven't met their burden. Now, everything I've just discussed was to show you that the claimants haven't satisfied their burden of proof relating to the structures above the Morocco interaction level. What's then left are the transactions themselves between Samir and Q1 under the MCTA. And there are a few points that I'd like to touch on in relation to that. First is the proper characterization of the transactions. And you have my essential point. I made it right at the start. It is absolutely plain as a pikestaff that this is a financing transaction. Everybody understood that at the time. You can see it in the letters of the from the Samir people, from the claimant side at the time when they were talking to Samir, they were referring to it as providing liquidity. You can see it also in relation to what was said to the Office d'Échange. We've got statements from Mr. Zouak accepting that's from Samir's perspective, they were looking at it as financing. And it's very important. It's from every single person concerned, this was working capital financing for Samir. That's how the transactions were presented to the only government agency that knew about it, and that's how the government understood it. And as Mr. Zurek confirmed, he was involved in these meetings with the Office d'Échange. Carlyle, on the other hand, is concerned about one thing and one thing only. They do not want this to be characterized as a loan, because otherwise they have to pay tax in the US, and they don't want to have to pay tax. And you've got the evidence from Mr. Zurek on the slide for that. Now, in this arbitration, Carlyle wants to resile from its characterizations of financing, and the tribunal must understand what they're doing. They represent to Samir and the Moroccan government that they're providing finance, and they now say it was never finance. And Mr. Zurek's rather flippant response when asked about the characterization, and he went to demonstrate that. You know, he doesn't care how they interpret the relationship. He was perfectly content, it appears, for the entire transaction to be misrepresented and misunderstood in Morocco, as long as everyone agreed that it involved the transfer of proprietary interests so Carlyle wouldn't have to pay tax. You're told instead by Mr. Walt that the fact that the structure incorporated a put option but not a call option means that it cannot be a commodity repo financing. We've shown you the industry publications. It's crystal clear that that is not the case. There's no sensible reason why that would be the case. More importantly, of course, although Samir didn't have a call option, as Mr. Walk recognized, the transactions included a powerful commercial penalty for Carlyle not exercising the option. They'd have to pay back the haircut. We've put it on the screen, the slide. Now, we recognize that if it happened that oil prices increased dramatically during the very short maturity of these transactions, then there might theoretically have come a point where Carlyle chose not to exercise the option because of the size of the contractual penalty with the haircut and the premium would be more than compensated by the increase in transaction value. But that's not the end of the story. Who would Carlyle have sold the oil to, realistically? The oil's sitting in Samir's tanks. And the whole purpose of this is so that Samir has it so it can refine it. As we know from the New York court, it had actually probably refined it. But leave that out. Samir will obviously pay the market price for it. It's simply unreal to believe what the claimants are saying, that Samir was holding oil for Carlyle in its tanks indefinitely without any storage fee, pending a future sale by Carlyle in the market. The whole structure, very well understood by both parties, was that the oil in Samir's tanks was to be refined by Samir. And Mr. Zuek accepted that. And we've put the quote on the slide. They're a refinery, I expected them to do that. His only point was that they had to get my written permission or pay me first. We know what the New York courts have held about that. And ultimately, all roads lead to Samir. It was a financing. Second point, duration. Well, the claimants put great emphasis on the so-called commitment letter as evidence that this was a long-term investment. They kept coming back to it in re-examination as if it was some sort of solution. But there are a number of problems with that. First problem is, commitment letter makes clear it's binding on Samir, not Carlyle. Carlyle was simply extracting a commitment from Samir to enter into contracts with Carlyle if Carlyle wanted to, without Carlyle committing itself to anything. And we can put the quote, the relevant bit on the page. It's not intended to be and is not binding on VAM or any other person. And the other problem is that the commitment letter post-dates several of the transactions, which have short-term maturity. By the time it was entered into, 13 of the 16 transactions relevant to this dispute had already been executed, including the 3 swaps. The reality is Carlyle was flexing its financial muscle to force Samir to accept ever more onerous terms. The commitment letter makes no sense for Samir commercially. It's not evidence of a long-term commitment by Carlyle. This is a series of individual sales. There's no duration to this. It's not an investment project. It's just a group of sales, of sale and purchase transactions. And the third and final point about the transactions is the New York Supreme Court conclusions. And the critical point that it's important that you understand is that the US court, with the benefit of the depositions of several Carlyle employees, including Mr. Zuek, concluded that Samir was refining the oil upon delivery with the tacit consent of Carlyle. And it did that on the basis of one of Carlyle's witnesses' evidence accepting that that was the position, that it was with the tacit consent, that they never objected. They knew it was happening, they never objected. See that in the judgment, it's recorded. And as we've made clear in our submissions, that conclusion suggests strongly that in reality, you cannot be satisfied that any of Carlyle's oil or refined products were still in the tanks in August 2015. And you heard Mr. Walk's so-called evidence that he that Samir did still hold commodities for Carlyle in August 2015. And I've put on the next slide some of the points coming out of that. He did no due diligence, just accepted the tank report at face value, didn't try and cross-check it, unable to form a view as to whether any of those authorities, any of those commodities actually belong to Carlyle or were pledged to third parties. He accepted that there were irreconcilable contradictions between those tank reports and other contemporaneous reports, including the official document, the custodian certificate. And the fact of the matter is, of course, their case, Carlyle's case in the US, is that Samir was lying to it and defrauding it. So the idea in that context that one can take, when it suits, at face value, unverified tank reports that don't even say that anything about Carlyle, I'm afraid it's just not serious. That's not evidence. Now, on the law side, for active investor contribution, duration, and risk, I've just got to deal with a couple of points here, including one raised by Mr. Wordsworth in opening. The active investor requirement is grounded in the express language of the definition of investor in Article 1027. One who attempts to make, is making, or has made. And the claimants have focused on our reference to Standard Chartered Bank, and we've put the extract again up for that. And they say the situation is different in Standard Chartered, Mr. Always said in opening, because the BIT in that case spoke of investment of an investor, and not an investment made by an investor. Well, quite. So even without the treaty language, that tribunal held that that treaty required an active investment. Our case is far stronger because one of the essential predicates of the tribunal's jurisdiction is conditioned on the requirement that to be an investor, you have to be the entity making the investment. And Mr. Always said in opening, well, you know, our treaty uses the words own or hold to describe the form in which assets must be held to be protected. As we pointed out in our reply, that doesn't get them very far because the word made appears in the definition of investor. And the word own appears in the definition of investment. And the claimants elide those concepts the whole time. Unless the claimants are investors, it doesn't matter what they owned or controlled. Indeed, one might ask why the treaty parties did not define an investor as a person owning or controlling an investment, if Mr. Always right that that's what they meant. Why did they say a person who makes, is making, or has made an investment? Now, on Wednesday, Mr. Wordsworth asked me for more information about how Standard Chartered Bank has been received. And the answer to that question can be found in paragraphs 303 to 310 of our reply, where we set out a number of cases that adopt the same broad approach as Standard Chartered Bank. But in circumstances where our treaty is on completely different language and positively requires that an investment be made, there's a clear sense there that the parties intended that only active investors, investors who were active in the creation of an investment, in the making of it, can be deemed protected. I'm not going to address you on contribution, duration, and risk, other than to say that on duration, the claimants say there's no such requirement. We showed you in the footnote that it's clearly there. In terms of the characteristics, the dispute between us is this disjunctive or, but the claimants just read the risk and contribution. They don't read an asset with the characteristics of an investment, including, that goes before it. And that's extremely important. I've already explained the point. Unity of investment, fine. That applies when you're looking at the Salini type criteria, contribution, etc. But it's unity of investment, not unity of investor. Critical difference. Each of the claimants has to establish independently.
While let me get a time check for you from the secretary, so that we don't, now that you were drinking water.
Been an hour and a half.
Okay,
Exactly.
So yeah, take your, if you need some additional time, we will give the same time also, of course, to claimant, but so that, that you know where you are.
I'm very, very nearly finished. Apologies if I've been going a little quickly, especially to Diana.
Take your time. Take your time, and let's go on.
each of the claimants must establish independently that they meet the jurisdictional requirement of the FTA. It's not enough to say, for example, that a contribution by know-how was made by CCM, and that excuses all the other claimants from needing to show that they made their own contribution. Equally, it's not enough for them to say the onshore feeder took some investment risk, assuming they could prove that, and therefore that all the other claimants can benefit from that. That's just not how it works. Now, final point, ownership and control, the final objection, objection 2. So far as the law is concerned, the disagreement between the parties centers on the meaning of own or control in the definition of investment in Article 10.27. And as I explained in opening, the authorities on this point, particularly NAFTA authorities such as Thunderbird and BMEX, are very clear. We put BMEX paragraph 205 on the slide so you can see it again. We've explained there that I explained in opening quite carefully the meaning that the tribunal saw for the word control in NAFTA Article 1117, and the way that they sought to analyze what that means. And in essence, as you know, if you have an equity interest, but it doesn't allow you to direct the company's actions, but you have some other way of controlling the company's actions by contract, say, that's de facto control. But every single one of the instances of control relies on a proprietary interest. Some form of ownership is required to have control. Now, in opening, Mr. Ordway said those cases are not relevant because they were brought under Article 117 of NAFTA. That came as a bit of a surprise to us, given that it was the claimants that put those cases on the record, describing them as, I quote, directly pertinent. Now they realize that they're not good for them, they don't like them anymore. But even then, the claimant's new argument that these were cases brought under NAFTA Article 1117 and can therefore safely be ignored is just wrong. Chain of reasoning is easy. NAFTA Article 1117 provides that an investor can bring a claim with respect to a local enterprise that it owns or controls. That language is replicated in FTA 1015(1)b, which you've already looked at. So BMEX is relevant to the interpretation of that provision. And the words owns or controls also appear in the definition of investment in FTA Article 1027. Given the well-known interpretive canon that the same words used in different places in the same treaty are ordinarily to be given the same meaning, the BMEX analysis is clearly relevant, directly relevant to the interpretation of the definition of investment. With respect to the other authorities on which the claimant rely, we've been through them in our reply memorial on jurisdiction, paragraphs 209 to 220, and Annex B, Table 2, and we showed that in all but one of them, the entity said to be in control of the company had at least a minority stake in the company. So those cases are of no assistance to the claimants and support what we say. The only one that breaks that pattern is Myers in Canada, and we say that the tribunal in Myers just got it wrong. But even if it wasn't wrong, the tribunal was clearly moved by the very extreme facts of that case. And I'm not going to go into them again, but you will perhaps be familiar with them. But in any event, we're a world away from that situation. Mr. Zueck confirmed yesterday that the alleged control exercised by CCM was a contractually delegated power. No individual of CCM, employed by CCM, owned any part of Q1 or 2014-1, and Q1 and 2014-1 weren't funded by CCM. CCM had no expectation to share in the profits of Q1 and 2014-1. It was just paid a fee under its management agreement for services rendered. And in the rejoinder, and again in opening, the claimants made an attempt to escape those facts and say that CCM's situation is comparable to SDMI in the Myers case. But that's just wrong. It's not remotely comparable. CCM was entitled to fees from Q1 and 2014-1 under the management agreement, but that's not the same as a share of profits, which is one of the arguments that was used to demonstrate STMI's control over Myers Canada. They also said that CCM made all investment decisions on behalf of Q1 and 2014-1 and was the face of the transactions. But all that means is it was its limited attorney in fact. That's no different from if the CEO of a company is the face of the transaction. The company can only act through its officers, through whoever's delegated to it. That doesn't make that person the owner or controller. So SD Myers is of no assistance. The burden of proof, remember, as I showed you in opening from Thunderbird, is beyond all reasonable doubt when they're showing de facto control. And the evidence you heard yesterday shows that CCM doesn't come close to meeting that burden. So in conclusion, members of the tribunal, we say this is a case which fails at the first hurdle. The claimant entity bringing the claim, even if they presented you with the perfect evidentiary record reflecting the investments they'd made, the efforts they'd gone to making it, the things that you'd expect of a serious claimant in ICSID proceedings, they would lack standing to bring it. And that is inescapable from the proper interpretation of Article 1015(1), as confirmed to you as the common understanding of the parties to the FTA. Those entities, on their own case, have only suffered reflective loss, and that puts them outside the four corners of the treaty. Secondly, they're very far from presenting you with anything like a perfect evidentiary record. In fact, what you've seen is habitual reliance on assertion, and you can't rely on the assertions because each time we probe them a little bit, they turn out to be wrong. And you've got the significant amount of withheld evidence, basic evidence which must be available. Indeed, we understand in some cases from the evidence that it is available, but hasn't been produced, and you have to draw inferences for that. And finally, the reliance, the silver bullet reliance that's put on CCM's alleged control is simply misguided. It was a professional services provider with powers strictly delineated by contract. The claimants established this structure, no doubt for very sound tax reasons in structuring their affairs on the basis of detailed guidance from lawyers about how to do that. They made that choice, and if that, as it does, means that they don't have protection under this treaty, then that's the position, and they can't complain that it's unfair when they take the benefit on one hand. So for those reasons, individually and cumulatively in my submission, you must decline jurisdiction over this claim. Unless I can assist you further, those were my submissions.
Thank you. Thank you, Mr. Harris. Let us get a time check from the secretary.
1 hour, 37 minutes, and 43 seconds.
So, Mr. Ordway and Mr. Yohai, you have also a similar amount of time between 1 hour and a half and 1 hour and 40 minutes, so that we are on a level playing field. And we have now a break of 15 minutes, and we will take it and we will then come back. It's 17:55.
Actually, Mr. Chairman, simply because we've been going on a while, would it be possible to extend it to a little bit longer, at say to, well, it'd be 12 o'clock our time?
Of course.
Possible?
12 o'clock Washington time, no,
Washington time.
Or New York time. Okay. Yeah. Very good. So 12, which should be then for those who are on Paris time, 18. Very good. No problem at all.
Thank you.
Mr. President, I think everyone is back in the room.
Excellent. Thank you very much. We resume the hearing, and I give the floor to claimants for their closing presentation. Mr. Ordway or Mr. Yohai, you have the floor. Mr. Ordway, I think it will be.
Yes, thank you, Mr. President. Mr. President, members of the tribunal, there is a fulsome body of evidence related to jurisdiction before you, almost all of which came from the claimants. And let me say at the outset, the idea that somehow the evidence must be documentary and that the testimonial evidence is really of a second order of magnitude, we don't accept. We have submitted a tremendous amount of evidence, both documentary and testimonial, to support our position on jurisdiction here. And when coming into this hearing, you read hundreds of pages on the party's submission. 2 days ago, you heard 4 hours of opening presentations, after which the members of the tribunal posed several probing questions, legal and factual, to the parties. And you heard live testimony from claimant's fact witness, Mr. Zuick, yesterday. And as I will revisit for this tribunal, Mr. Zuick reaffirmed the foundational facts about the nature of claimant's investment, establishing why a finding of jurisdiction is appropriate here. So I look forward in this presentation to providing responses to the questions that the tribunal highlighted and posed to the parties on Wednesday, and obviously any others that you might have. Let me start with the issue of the burden of proof, which was raised by respondent, Mr. Harris, earlier today. Again, claimant's position has not changed at all, is that it is now respondent's burden to support their objections, because claimants have provided a prima facie case on jurisdiction, and it is based on the preponderance of the evidence. And I believe at some point Mr. Harris referenced a beyond the reasonable doubt standard with respect to one of the elements. We dispute that is the case. The entire case has to be, the burden is on the preponderance of the evidence. And we believe that based on that standard, we made a prima facie case and responded to Morocco's 4 objections. And based on the written submissions to date and what you heard during this hearing, we continue to believe that the tribunal should conclude that Morocco has not met its burden and that none of its objections have any merit whatsoever. Put simply, the success of Morocco's objections hinges on this tribunal's acceptance of Morocco's untenable readings of the FTA and its distorted and inaccurate version of the factual underpinnings of the investment at issue, which at the end of the day does not meet the actual evidence that we have submitted before you and which you have now heard. As did respondent, we will first turn to objection number 3. And turning first to the legal issue that Morocco has deemed its standing objection, the objection that according to Morocco's counsel allegedly could, quote, succeed even if you take the claimant's case at face value as to the facts. This objection turns on a single term that is nowhere to be found in the actual language of the FTA provision at issue, and that word is direct. We could turn to the language of the article. Article 1015A 1A provides that, and again, you've seen this language, but it bears repeating. A claimant on its own behalf may submit to arbitration under this section a claim that the respondent has breached an obligation under Section A, and that the claimant has incurred loss or damage by reason of or arising out of that breach. Again, the word direct does not appear in this plain text. And yet, Morocco, and it appears also the United States, are adamant that it should be read into it. The tribunal, however, must reject this position. We turn to Article 31(1) of the Vienna Convention, which, as I noted during my opening presentation, emphasizes the primacy of the FTA's final text in treaty interpretation. And it says the ordinary meaning must be given to the terms of the treaty. As stated by the International Law Commission, it is the text of the treaty that must be presumed to be the authentic expression of the intentions of the parties, and that the elucidation of the meaning of the text, rather than an investigation ab initio of the supposed intentions of the parties, constitutes the object of interpretation. And I might add, as I'm sure the tribunal is aware, that the text of the Vienna Convention was basically the result of a meeting of the Vienna Committee at which the objective and subjective components were discussed. That is to say, those who considered the subjective approach to interpretation and those who considered the objective approach. And what won out, as is well known, is the objective approach. That is to say, the approach which focuses on the language of the exact text of the treaty. And that is an approach that has been echoed in many cases, including the Wintersall and Methanex cases, which basically say, this is from Wintersall, the starting point of all treaty interpretation is the elucidation of the meaning of the text, not an independent investigation into the intention of the parties from other sources. And from the Methanex case, the text of the treaty is deemed to be the authentic expression of the intentions of the parties. There's a reason why the tribunals have reached this conclusion, and that's because the text has to be the most important element. And we take respondents' point that this means taking all the provisions into account and context. And we believe when you do that, and particularly when you do that, that claimant's position and with respect to this objection is the correct position. I would note that had Morocco and the United States truly intended to preclude recovery of indirect losses, because that's the key issue here, under Article 1015(1)(a), rather than rely on an outdated, inapplicable, customary international law, they could easily have drafted or even amended later the FTA's language to reflect that intent. Indeed, claimants would argue that the United States in particular might have done so after seeing 6 NAFTA tribunals expressly reject the same arguments to exclude claims for indirect damages under NAFTA Article 1116. And on that slide, you will see those cases, NAFTA cases, in which the tribunals expressly rejected the arguments that are now being made by respondent. Waste Management, GAMI versus Mexico, United Parcel Service of America, Pope and Talbot, S.D. Myers, and Mondev. 4 out of the 6 decisions, by the way, were rendered prior to the signing of the FTA at issue here in June 2004. The 5th, mere months after signing, and the 6th, just a few years thereafter, although nearly 15 years ago from today. However, the language of FTA Article 1015(1)(a) was fixed without any reference to direct losses, and it remains devoid of such reference to this day. One would think that if this was such a clear element, that it would have been amended, there would have been some formalization of change in the text of the treaty, but that has not happened. And it bears quickly noting once again that in Pope and Talbot and S.D. Myers, two of the cases mentioned in the preceding slide, the United States, in fact, argued the opposite of what it argued today, where the qualifying investment is not a separate company, quote, any damage to the investment will be a direct loss to the investor, and the investor will have standing to bring a claim under Article 1116. Respondent has sought to try to distinguish that language, but claimants believe that this attempt does not override the import of that statement and the statement also in Pope and Talbot. And I remind the tribunal that these statements were given 2 years prior to the signing of the nearly identically worded FTA, when there was still ample time to revisit this position and draft Article 1015(1)(a) with the prohibition on standing for indirect losses that the U.S. claims should be reflected in the text. Now, contrary to Morocco's position, the fact that Article 1015(1)(a) is in fact silent as to whether losses must be direct or indirect cuts in favor of, not against, claimants' interpretation. Mere silence in Article 1015(1)(a) in no way precludes claimants from seeking losses on their own behalf simply because they owned or controlled an enterprise that sustained the direct losses is incorporated in a third state rather than in Morocco. And this is, by the way, a very important component, the fact that it's in a third state. So many of the cases that were cited and that have been cited by respondent simply don't address this particular issue. And this is where we believe the Capis versus Guatemala case is very instructive and strongly supports claimant's position. We note that respondent in its presentation earlier focused not on the language of the case itself, but on the dissent, which is not atypical of respondent's position in many situations like this, where in fact, generally speaking, where a decision goes against respondent's position, respondent argues that the case was obviously wrongly decided. Obviously, we disagree. The U.S. claimants in Capis versus Guatemala sought damages arising out of Guatemala's breach of the CAFTA, DR CAFTA, with respect to their investment in 2 mining projects in Guatemala. Claimants made the investment at issue through a local entity called Exploraciones Mineras de Guatemala, Exmingua. Guatemala raised the same objection that Morocco is raising here, namely that claimants cannot recover for their own indirect losses under Article 1016(1)(a) of DR CAFTA, which is identical to the language of Article 1015(1)(a) of the FTA. The majority, however, denied Guatemala's preliminary objection, holding that it was, quote, unable to find anything in the treaty text itself, including the context of various provisions related to Article 1016(1), which would impose a limitation of direct losses or an exclusion for derivative or reflective loss onto Article 1016(a)'s open language about a claimant pursuing its own losses on its own behalf. In reaching its conclusion, the majority correctly pointed out that, quote, it would have been possible for the DR CAFTA parties to include a reference to direct injury or direct causation in the treaty provision, but they did not do so. And in fact, the words direct or indirect appear nowhere in the provision itself. Similarly, in this case, had the parties to the FTA intended to preclude recovery of indirect damages under Article 1015(1)(a), they could have easily stated that this provision applies only to direct loss or damage. Yet, similar to the parties to the DR CAFTA, they chose not to do so. In further support of its conclusion, the majority stated that it had not been shown anything under Article 31.3 of the Vienna Convention that could qualify either as a subsequent agreement or a subsequent practice. Here too, for the reasons to be discussed in a moment, there is nothing that can validly and properly be considered a subsequent agreement or subsequent practice. Nor did the Capus majority consider relevant Guatemala's invocation of the U.S. Statement of Administrative Action, which Morocco too recently submitted as one of its exhibits as RL authorities 113 in this proceeding. They stated, among other things, that the word direct and indirect were not included either in the NAFTA text itself or in the subsequent DR CAFTA text, notwithstanding considerable debate about this very issue in the interim. The same rationale applies here. Let me move to the next slide. The majority also rejected Guatemala's argument that Article 1016b would be rendered effectively useless, the effet utile argument, if claimants could recover indirect damages under Article 1016(1)(a), finding that, quote, for a treaty interpretation to rest on an effet utile conclusion, a tribunal must be convinced that the alternative interpretation would leave a treaty provision with no effective meaning at all. Note how categorical the language is in that majority's decision. The majority did not believe that the Bilcon versus Canada tribunal, which the case of which respondent has emphasized, that they had made such a finding with respect to NAFTA Article 1117, and stated that it too was unable to make such a finding under DR CAFTA, given that it could imagine various scenarios where a claimant might prefer to bring a claim under 1016(1)(b) rather than Article 1016(1)(a) for the same breach. There is no reason for this tribunal to reach a different conclusion with respect to the FTA here. As I will discuss a little later when responding specifically to another one of the questions that the tribunal posed from when.
Can I just ask? I'm sorry to interrupt, Mr. Ordway.
Yes.
I don't know whether anybody else is suffering from the same thing. I still haven't received a copy of your presentation. We asked for it again by email about 5 minutes ago. I just wonder. I appreciate your team are probably all watching their screens. So
no, yeah, I can assure you it's on its way. There was a
my apologies. It must be a technical error because we absolutely wanted you to receive it in a timely fashion. So my apologies.
We had one glitch, but it will be with you absolutely.
I don't want to interrupt. I just would like to see it.
No, not a problem. Not a problem.
Thank you.
Finally, in concluding, the Capus majority reiterated that the text adopted in Article 1016(1)(a), quote, contains no language suggesting that it be interpreted other than through the ordinary meaning of its terms, and the particular terms adopted are not consistent with barring a claimant from pursuing on its own behalf a claim for losses it incurred just because these losses may have been incurred indirectly rather than directly. Now, given that Article 1015(1)(a) of the FTA contains identical language to Article 1016(1)(a) of the DR CAFTA, the same conclusion should be reached by the tribunal here. Now, at this juncture, I would like to reiterate that there is also no subsequent agreement, as has been argued, and no subsequent practice that can or should be incorporated pursuant to Article 31(3) of the Vienna Convention into the tribunal's interpretation. As I noted during my opening presentation, there are specific agreed upon mechanisms for effectuating an amendment or a joint interpretation of the FTA. They're there for a reason. They're there precisely so that parties wishing to demonstrate an agreement on interpretation, do so in a formal manner. And again, Article 22.2 of the FTA governs amendments, and Article 1021.3 governs joint interpretations via a decision of the Joint Committee. Neither of those mechanisms have been used, and so there simply cannot be a subsequent agreement here. Now, it has been argued that there is no need for a formal written agreement between the parties, and that some commentators and tribunals have noted that express amendment or joint interpretation procedures set forth in the treaty need not be followed. But that would be plainly wrong and illogical here. It is wholly unreasonable for the FTA parties to forego these agreed upon mechanisms and present the very effet utile issue the Capus versus Guatemala majority was considering. If the parties have no intention of utilizing these express mechanisms to alter the scope and meaning of the treaty, and tribunals must accept any semblance of an amendment, no matter what the form, the mechanisms would be wholly superfluous. And I might note that respondent in its presentation earlier referenced in support of its position to Gazzini, one of the interpreters, and I think it was on page 188, concerning taking into account subsequent agreement. But the subsequent agreement that was being referenced there was precisely these formal mechanisms, okay? And counsel for respondent omitted to mention that, but it's obviously a critical point. Moreover, the article that has been relied upon by Morocco by Professor Crawford that says not every coming together of the states is equal to every coming together of states. In other words, you have to look at what it is that is being argued as an agreement and consider not only first of all, if there is a true agreement within the requirements and strictures that should properly be taken into account to make that decision, but also weighing those factors, and we'll come to that, as to what weight should be given to any such alleged agreement. Now, in addition to there being no subsequent agreement, there is also no subsequent practice pursuant to Article 31.3b of the Vienna Convention. Now, you saw this definition a couple of days ago. Subsequent practice must be a concordant, common, and consistent sequence of acts or pronouncements which is sufficient to establish a discernible pattern implying the agreement of the parties regarding its interpretation. Now, this is from the source that respondent has relied upon, Mr. Gazzini. However, there is no discernible pattern here with respect to the interpretation of 1015(1)(a). In all fairness, this is the first time there has been any submission by either of the parties, to our knowledge at least, regarding this particular FTA. And that is a fact. And although Morocco and the United States refer in their submissions their submissions were made in the context of another treaty, NAFTA, those should not be taken into account. Morocco is, of course, not part of NAFTA, and claimants did not bring this case under NAFTA. So when you are looking to a practice, you have to look at the practice with respect to both parties. And since Morocco was not a party to NAFTA, you cannot logically and fairly look to practice between the United States and another party. It has to be the practice with respect to the two parties to the treaty. Now, a point I made previously, and I'd like to reiterate, goes to the violation of good faith issue Article 31, it says a treaty shall be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty in their context and in the light of its object and purpose. And claimants further reiterate that to the extent the tribunal chooses to view the purported agreement between Morocco and the US, which again, in our view, is a purported agreement and does not qualify as an agreement because the formal mechanisms were not utilized. But if they're to view that supposed agreement as some form of subsequent agreement or subsequent practice, taking it into account here in this arbitration, in our view, would plainly violate Article 31(1) of the Vienna Convention. As noted, that provision expressly requires treaties to be interpreted in good faith. Indeed, this principle of good faith was essentially the subject of a couple of the tribunal's questions on Wednesday, so I address them now. With respect to the tribunal's first question in this regard from Wednesday, on whether it matters that a purported subsequent agreement or subsequent practice arises in the context of an ongoing litigation, claimants believe that, yes, it does matter to the extent the potential for bad faith and unfairness to the investor due to the sudden and total deprivation of legitimate standing are heightened in the middle of a live dispute. Whereas here, there is an attempt to modify or amend the treaty under the guise of an interpretation, and then have that alleged interpretation apply excuse me, retroactively to an ongoing case. Tribunals such as Pope and Talbot versus Canada have viewed the amendment skeptically and as potentially inconsistent with due process. And we would refer you to CL 0109, our authority paragraphs 13 and 47 in that regard. In such circumstances, there is a strong presumption against retroactivity. In addition, scholars have emphasized the potential unfairness to claimants in this situation. Wiramantri, a source of treaty interpretation, has stated very expressly that care must be exercised in this situation, as the investor may face unfairness if the meaning of a treaty can be modified in this way after a dispute has arisen. Now, respondent has argued, oh, there should be no problem with this because there have been years and years of clarity on this, and because of decisions in NAFTA and so forth. All of that really ignores the fact that this is really the first time that this has arisen in respect of the Morocco-US FTA. And that has to be respected, because when claimants filed their claims, they were not looking at the history of submissions with regard to NAFTA. They were looking at the plain language of the treaty, the US-Morocco FTA, and that has to be respected. And again, in Methanex versus the United States, the three NAFTA parties, they contended that they had a subsequent agreement on the interpretation of a particular NAFTA provision, but it was based on their submissions in that case. And regarding the matter, Wiramantri commented exactly here that they would face unfairness if the meaning of a treaty can be modified in this way after the dispute has arisen. Now, with respect to the tribunal's second legal question from Wednesday, which was even outside the specific context of ongoing litigation, tribunals and scholars generally have warned against the dangers of what Morocco and the US are trying to do in this case, retroactively and unfairly modifying or depriving the rights of an investor after an investor's treaty claim already has been filed. For example, in Sempra versus Argentina, the tribunal rejected Argentina's invocation of a U.S. State Department letter setting out a position of a then current U.S. official to a former U.S. official asked to testify in a different arbitration, noting that, quote, the view of the state does not make international law. The tribunal further held that even if the interpretation were shared, it should not be followed, stating states are, of course, free to amend the treaty by consenting to another text, but this would not affect rights acquired under the treaty by investors or other beneficiaries. To further make its points, the Sempra Tribunal also referenced decision on jurisdiction in Plama Consortium versus Bulgaria, highlighting the holding that any denial of advantages to which an investor might have rights should not have retrospective effects, as such a situation would result in making legitimate expectations false at a much later date. Morocco's own authorities recognized the limitations of applying a rule of retroactivity. Again, this is Dr. Tarcisio Gazzini, a commentator submitted by Morocco, as I previously mentioned, has recognized that a subsequent agreement that purports to amend the treaty at issue cannot be binding on pending proceedings because there is a need to protect the investor and to ensure that the treaty provides a stable, legal, and predictable environment. Here, Morocco and the United States have done just that. They have sought to amend the FTA, and in our view, radically so, far beyond any position that the US has ever taken to date with respect to similar treaties, by reading in a new term that simply does not exist in the provision at issue. They may be able to do that on a going forward basis, but as Gazzini, one of respondent's authorities, or authority that respondent has relied on, has said, that amendment, quote, does not affect the settlement of pending disputes or disputes that have arisen before its entry into force. Now, non-retroactivity is entirely consistent with the good faith principle embodied in Article 31A of the Vienna Convention. Claimants are entitled to pursue their claims under the FTA as it existed at the time they brought their claim. Were it otherwise, the incentives for the parties to that treaty to gin up self-serving interpretations of the treaty are potentially perverse. And in these particular circumstances, where you have a purported subsequent practice that is not actually a practice, it cannot be a good faith interpretation of the FTA to apply this new amendment retroactively against claimant. At best, it can be applied only to future situations. Now, looking at the root of Morocco's and the United States' position that the FTA claimants must suffer direct losses, both refer to the so-called Barcelona Traction Rule, which seeks to distinguish between a company's rights and its shareholders' rights. However, as we've previously stated, the very body that issued the Barcelona Traction decision, the International Court of Justice, has expressly acknowledged that the Barcelona Traction Rule has no application in contemporary international investment law, which is dominated by treaty. In fact, the US departed systematically from this rule in the bits that they entered into subsequently. And as also previously stated, the tribunal in Cube Infrastructure held that the principle of separate legal personality, another way of referencing the Barcelona Traction Rule, can be altered by treaty, and investment treaties almost always do so. Here, Article 1027 of the FTA plainly altered the purported principle by defining investment very broadly as every asset, including one's owned or controlled directly or indirectly. And because claimants owned and or controlled directly or indirectly the commodities and the contractual rights in accordance with the FTA, there is no hurdle presented by the Barcelona Traction Rule. Now, Morocco also has relied on cases such as Postova Bank and others in that line to argue that shareholders may not claim losses with respect to assets held by the companies in which they hold shares. However, the Postova Bank case in particular is inapplicable, as we have noted, because there is no limitation in this FTA that requires only the ultimate owner or beneficiary of the assets of issue to submit claims to arbitration. And claimants have clearly stated the basis for their standing in accordance with Article 1027 of the FTA. And as we have also noted previously, the Postova Bank investments were not qualifying investments, rendering the discussion regarding whether the claimants were qualifying investors irrelevant. Moreover, as Professor Schroer, who, by the way, Morocco could have called as a witness in this proceeding, but did not, explained in his legal opinions, a large number of tribunals have refuted the very position taken by the Postova line of cases. And I refer, again, I'm trying to make this as concise as possible, but there are a number of cases that Professor Schroer has cited to refute that position, and I would refer the tribunal to those cases and to Professor Schroer's opinion. I return to Mera versus Serbia, where the tribunal unequivocally held that in situations where a shareholder controls, legally or factually, the company that owns the assets at issue, tribunals may consider those underlying in assets, the assets, to be the investments of the shareholder. And because the Mera claimant not only invested in its investment vehicle, but also through the control of such vehicle, the tribunal held that the claimant was entitled to, quote, bring claims not only for the impairment of the value of its shares in its subsidiary, but also for the impairment of its subsidiary's assets. Again, this is just one of numerous cases, numerous tribunals that have reached a similar conclusion. Therefore, Morocco's reliance on the Postova Bank line of cases, rather than the plain language and ordinary meaning of FTA Article 1015(1)(a, is futile. Now, I return again to the language of FTA Article 1015(1)(a to note that the plain language and ordinary meaning of this provision is very straightforward. It simply sets out the prima facie requirements for submitting a Chapter 10 investment dispute to arbitration. It does not require proof of breach or proof of damages or of a specific amount of damages. And this is very critical because while I heard Mr. Harris say that we are trying to argue the merits of this case, I disagree. I think it's Mr. Harris who, wherever possible, does this by alluding to the damages issue. And regarding identical language, the Capus versus Guatemala majority opined that the phrase on its own behalf plainly refers to the entity whose interests are being pursued. And again, that's language in the DR CAFTA, which is identical to the language in this treaty. And the phrase incurred loss or damage refers to an alleged result. That's what they ruled. And the phrase by reason of or arising out of a challenged state action refers to an alleged causal link. So claimants meet these prima facie requirements because they have brought their claim on their own behalf, not on behalf of a locally incorporated company, which is the only other option in FTA Article 1015, and they have sufficiently alleged losses due to Morocco's improper actions, which constitute a breach of the FTA. The plain language and ordinary meaning do not require anything further. And again, although respondents would seek to dismiss these decisions, we have noted decisions such as Mikula versus Romania and Total versus Argentina. They established that neither claimants as a whole nor each claimant individually needs to prove damages or quantify their damages at the jurisdictional stage. Respondents, though, having been the ones to advocate the bifurcation of these proceedings, have nevertheless repeatedly sought to insert these merits, damages issues based at issues at this stage in order to complicate the jurisdictional inquiry as much as possible. But as stated in Mikula, quote, the extent or existence of actual harm suffered by one or more of the claimants, if respondent is held liable, need not be addressed at this jurisdictional stage. And in Total, the Total case, prima facie evidence that Total may, I stress the word, may have suffered economic prejudice from Argentina's action was sufficient for jurisdictional purposes. And then the Bywater Gulf versus Tanzania tribunal even held that, quote, the absence of economic loss or damage is primarily a matter of causation and quantum rather than a necessary ingredient in the cause of action of expropriation itself. That said, contrary to Morocco's assertions, claimants have indeed suffered immense losses, which I will discuss in more detail in the next section of my presentation. But I repeat, the extent and even the existence of those losses is plainly an issue for the merit stage, not this jurisdictional stage. And before I move on to the key factual issues that have come up during the course of the hearing, while we're on Article 1015(1)(a), I'd like to address two other questions that the tribunal raised from Wednesday. One of them was how the principle of the unity of the investment feeds into claimants' positions on Article 1015(1)(a). To quickly revisit the principle, the unity of the investment principle, as affirmed by the legal opinion and authorities before you, encourages tribunals to step back and view all of the elements of an investment as an integrated whole, rather than viewing discrete transactions and activities in isolation when evaluating whether there is a covered investment. And this is precisely what respondent has done, which is to try to separate them, isolate them, and that is not what should be done if you're going to honor the unity of the investment. Even if a singular transaction or activity might not qualify as an investment on its own, it may unquestionably qualify as part of an overall investment. And the principle is particularly important here, where claimants' overall investment involved various written agreements and a series of 16 individual investment transactions, part of a intentional of a plan to have many, many more such transactions. But those transactions gave rise to claimants' ownership and control of commodities and contractual rights. And although Morocco has tried to pick all the pieces apart, the unity of the investment principle must prevail. And by the way, how it feeds into Article 1015 and claimant's interpretation, as just noted, 1015(1) concerns the submission of a claim to arbitration, specifically a claim pertaining to an investment dispute. In order for a dispute to be an investment dispute, which is an undefined term in the FTA, The 1994 U.S. model BIT definition indicates that it must relate to, quote, an alleged breach of any right conferred, created, or recognized by the treaty with respect to a covered investment. In order to determine what a covered investment is under the FTA, however, one must look, not only one must look at the definition in Article 1027, one must also keep in mind the unity of the investment. It is claimant's position that not only does Article 1015(1)(a) fail to have any reference to direct or indirect losses, and as such, there is no limitation on the types of claims that an investor may bring pursuant to Article 1015(1)(a). But the broad definition of investment in Article 1027, which expressly covers indirectly owned or controlled assets, reinforces that there is no prohibition on claims for indirect losses. And the unity of the investment principle also supports the protection of indirect investments in that the investment is protected even if certain activities occur by way of an intermediate entity. And that is how the principle should be applied in the context of the corporate structure. If indirect investments are expressly protected under the FTA, there is no logical reason why indirect losses are not covered. Now, the tribunal's, I think its fifth question from Wednesday went to a different issue, which was what the interplay between 1015(1)(a) and 1015(1)(b) would be under claimant's understanding of Article 1015(1)(a). Now, part of this question may have been aimed at raising a potential effet utile issue, similar to the one raised in Capes versus Guatemala. But as stated earlier, we think the tribunal should reach the same conclusion. There is no such effet utile concern here. As the Capes majority noted, for a treaty interpretation to rest on an effet utile conclusion, beyond simply construing the ordinary meaning of treaty terms in their context, a tribunal must be convinced that the alternative interpretation would leave a treaty provision with no effective meaning at all. Now, Mr. Harris has argued that that's not what would happen here, but that is what would happen here, and we disagree vehemently. That would not be the case here, because Article 1015(1)(b) has its role in allowing claims to proceed on behalf of a locally incorporated enterprise. As the Capes versus Guatemala majority found, there may be valid strategic reasons for why an investor would proceed via Article 1015(1)(b) as opposed to Article 1015(1)(a). For example, as the Capes majority suggested, if the local entity remained a going concern, then the controlling shareholder may find it more desirable to bring a claim on behalf of the enterprise under 1015(1)(b), in which case any damages award must go directly to the enterprise, not the shareholder, in accordance with Article 1025(2) of the FTA. That in turn allows for the protection of other investors in the investment or potential creditors of the local enterprise. However, that consideration really is not at issue here. Claimants are effectively suffering all of the damages arising from the Moroccan government's improper actions, and they are the only ones who are entitled to bring the claims here. There are no other creditors. There are no other investors, just claimants. In addition, to the extent that there was any such concern of unrecompensed, albeit unknown, claimants, investment tribunals have the ability to fashion relief that would guard against the risk, but not deprive claimants of jurisdiction. Accordingly, claimants do not view its position as impacting Article 1015(1)(b) in any way. In sum, Morocco's standing third objection must be dismissed because interpreting the provision in accordance with Article 31(1) of the Vienna Convention, the plain text and ordinary meaning of Article 1015(1)(a), does not impose a limitation of direct losses, and says nothing otherwise about claims relating to an enterprise incorporated in a third state. And that is extremely important. This is a case involving claims relating to an enterprise incorporated in a third state. And there is no subsequent agreement and no subsequent practice that must be taken into account pursuant to Article 31.3 of the Vienna Convention. And the parties certainly have not entered into a written amendment or joint interpretation pursuant to the mechanisms in the FTA. To even recognize and incorporate any purported subsequent agreement or subsequent practice would be a blatant violation of the requirement of good faith interpretation in Article 31.1 of the Convention. As we've stated, for the reasons set forth, Barcelona Traction is inapplicable and the Stoic line of cases are wrongly decided. Claimant's position does not present the policy issues on double recovery or unprotected creditors, investors that the United States has previously raised in NAFTA cases. And finally, and most importantly, claimants do in fact meet the prima facie requirements of Article 1015(1)(a). Again, notwithstanding that claimants have suffered losses, there is no need to prove these losses at this early jurisdictional juncture. Now, before I address the rest of Morocco's three objections, I would like to turn first to the facts purportedly underlying them. Claimants have shown that the entire investment structure was conceived, set up, and run by one of the claimants, CCM, from its offices in New York in the United States. Indeed, as you heard Mr. Zuick testify yesterday, he personally formed all of the structures involved in this transaction from CCM's offices in New York City. And this was a holistic structure with CCM bearing responsibility for creating the investment vehicles it needed to raise funds that it ultimately invested in the Samir transactions. By contrast, Morocco's rendition of the facts can be boiled down as follows. To hear Morocco tell the story, the tribunal would have you believe that three independent and operational Cayman entities, Q1, 2014-1, and 2015-1, approached and proactively engaged a New York-based investment management company, CCM, as an independent contractor to merely manage their funds pursuant to limited management agreements. At one point, Morocco compared CCM to an outside attorney or accountant. This is just not the case. According to Morocco, these Cayman entities directed CCM to temporarily acquire oil and refined products via a simple short-term lending arrangement with a Moroccan oil refinery, Samir, which was supposed to store the commodities for them. And according to Morocco, before Morocco ever took a single action against Samir in August 2015, Samir, with Carlyle's full knowledge and even acquiescence, used up every drop of those commodities almost immediately. Based on this distorted and misleading factual presentation, Morocco submits that its actions against Samir did not give rise to any losses at all. In short, Morocco contends that claimants made no contribution, took no risk, and suffered no loss. But that position is fundamentally wrong, and that story that Mr. Harris seeks to present is not merely false, but it makes no sense. Although there have been numerous misstatements and mischaracterizations of fact in Morocco's written submissions and oral presentations, in the interest of time, I will address just a few of them. In turn, one of them is claimants were not directly involved in the investment transactions and did not sustain loss. Another, claimants made no monetary contributions or other contributions of value to the investment transactions. And then claimants' commodities were gone by the time Morocco seized the Samir refinery in August 2015. And finally, that claimants' investments was merely a short-term loan, a repo financing. to Samir. Let me explain why each of these contentions is wholly belied by the record evidence before you. To start with, the first false contention, the 3 Cayman Island vehicles that Morocco has really I chose to emphasize at every opportunity were plainly not independent vehicles that took the initiative to make the investments at issue. And this is an important fact. Respondent seeks to minimize this, but that mischaracterization was unequivocally refuted by Mr. Zuik's testimony yesterday. Mr. Zuik testified that from CCM's office in New York, he personally created VMF Q1, 2014-1, and 2015-1 as methods of raising funds for investments to be carried out by CCM, including the investments at issue here. He affirmed that the Cayman investment vehicles were legally established, but primarily paper entities that served the investment, not functioning subsidiaries. They did not have any employees, did not have any offices, did not have any infrastructure, and had no presence in the Caymans. Mr. Harris would has stated that this emphasis on the absence of employees and offices should be disregarded. We disagree vehemently. What this shows is that the emphasis on those entities as the supposed correct bringers of claims is totally misguided. Mr. Zuik explained that while these CCM-created entities had a nominal board presence, the directors expressly delegated any and all investment-making discretion, authority, and control to their experienced investment manager, CCM, and thereafter simply kept abreast of CCM's decisions. Again, respondent seeks to minimize the importance of what the contracts clearly say. All the agreements clearly gave all control to CCM. Given that Morocco has expressed confusion about the specific role of VMF Q1 in the overall Carlyle corporate structure, calling it the ultimate subsidiary of claimants in its opening presentation, Mr. Zuik clarified that VMF Q1 had no employees, no infrastructure, no offices, and no physical presence at all. The evidence is clear that CCM was vested with complete control over the investment. As Mr. Zuik affirmed yesterday, these agreements clearly gave CCM complete authority over what to invest or not invest in, without subject to any review by the directors or by any party. Although Morocco has pointedly ignored this express language of these management agreements, and again, in one case, as we noted from Mr. Taylor, one of their experts, didn't even review some of these agreements. But Mr. Zuik's examination yesterday was unequivocal. CCM was undisputably in charge of the investment on behalf of the entire investment structure. And let me be clear, there was not a single investment decision that the Cayman investment entities made on their own, nor could they. As I said on Wednesday, and Mr. Zuik's testimony confirms, all roads lead from and back to CCM. Indeed, this is really not a disputed point. As respondent's expert, Mr. Taylor, conceded yesterday during cross-examination, the investment management agreements give CCM full and exclusive authority to manage the investments on behalf of the vehicles. In fact, Mr. Taylor admitted that his accounting analysis of control may potentially contradict a legal view, and that at any rate, accounting analysis of control requires a significant amount of judgment. Really, then, this tribunal should rely on the plain text of the management agreement, which give CCM complete control over the investment vehicles involved in the Samir transactions. Now, just looking at the corporate structure chart, Mr. Zuik also clearly explained the connection between VMF Q1 and Celadon Commodities Fund the U.S. onshore feeder. As he explained, the U.S. onshore feeder owned 99.96% of all the all-important participating shares of the master fund, and the master fund in turn owned 100% of the participating shares of VMFQ1. In other words, the U.S. onshore feeder ultimately owned nearly all of the economic interest in VMFQ1. Mr. Harris continues to harp on the importance of the management shares, but the real economic interest is containing the participating shares, and that's why we have pointed this out. And there's been absolutely no attempt to withhold information or deprive respondent of information or documentation. This has been a recurring theme: complaints about lack of information, failure to provide documentation. Again, it would take too long for me to go into detail as to why those representations are simply wrong. On the swaps, for example, there was no documentation to reflect that information. There was no letter of credit. But again, on the flip side, any loss borne by VMFQ1, and we know from the financial statements of Celadon Commodities LT that VMFQ1 sustained a recorded 136 million in losses here, flowed up the chain throughout the investment structure. And why is that? Why did the losses flow up through the entire structure? Because of the nature of the participating shares. As Mr. Zwick affirmed, that even if a loss occurred at a certain vehicle, you had to look at exactly the economic relationships between the different vehicles in order to understand who was actually taking that loss. Here, the master fund contributed funds into Q1, and in exchange for its investment of capital, the master fund received participating shares. Those shares, as Mr. Zwick put it, received the economic benefit of these transactions. And we also know that in turn, the claimant U.S. onshore feeder held nearly all of the participating shares of the master fund. Consequently, Q1's losses were borne by the master fund and U.S. onshore feeder. As I've said, Morocco has raised a question regarding the management shares, but this is an example of misdirection, because when the inquiry is focused, as it should be, as I said, on the participating shares, Morocco has no leg to stand on, because it's the participating shares which were held by the master fund that constituted the economic interest. Now, why are management shares not relevant? Well, it's very simple. The VMFQ1 Articles of Association state that the management shares shall confer upon the holder the right in a winding up to repayment of capital. And then here's the important language: but shall confer no other right to participate in the profits or assets of the company, and no dividends shall be payable on the management shares. In other words, management shares comes with no economic interest, and here the economic interest in Q1 is held by the owners of the participating shares, who had the right to participate in the assets of the company and the right to receive dividends. It simply does not matter for jurisdictional purposes who held the Q1 management shares. Now, Morocco attempts to distinguish Q1 from the Cayman limited partner in Mason versus Korea. However, Mason fully supports claimant's position. In Mason, the tribunal found that the U.S. general partner had standing, not because it owned the shares at issue in that case, but because the U.S. entity had beneficial interest in those shares. Likewise here, claimants have shown that the U.S. entity atop the Celadon structure, the U.S. onshore feeder, had beneficial interest in Q1 through its participating shares of the master fund and the master fund's participating shares in Q1. Now, it is notable that Morocco has ignored the $136 million loss recorded by Q1 in Celadon Commodities audited financial statements for 2015. Instead, Morocco seems to suggest that there was something new or unusual in the way Q1 reported its financial condition in 2015. Not so. This wasn't some new structure that claimants devised in 2015 to clear up any issues on this point. Claimants note that the record also contains the 2014 audited financials for Celadon. Those have been disclosed, and they show the exact same ownership structure. Now, before I move on, I'd like to briefly reiterate Mr. Zuick's testimony regarding the jurisdictional basis for claimants Celadon Partners, TC Group Investment Holdings, and the Carlyle Group. I'll take each of these claimants in turn. Celadon Partners served as the general partner of the U.S. onshore feeder, and as such, it is responsible for the management and day-to-day operations of the U.S. onshore feeder, and in turn collects an incentive fee from the U.S. onshore feeder. Celadon Partners also appointed CCM to control and manage the U.S. onshore feeder's investments. As Mr. Zuick testified yesterday, he was also a partner of Celadon Partners. As to TC Group and TC Group Investment Holdings, Mr. Zuick's testimony yesterday was clear. As he explained, TC Group was majority owner of CCM, and together with TC Group Investment Holdings, TC Group wholly owned the offshore feeder, and the offshore feeder in turn held 0.04% of the participating shares of the master fund. Now, in its opening presentation, Morocco accused claimants of misrepresenting TC Group and TC Group Investment Holdings ownership of the limited partnership interests in the U.S. onshore feeder. But this is a manufactured issue aimed, I think, at confusing matters that are actually quite clear. At the time that claimants submitted their merits memorial, we articulated accurately the corporate ownership as it existed at the time of claimant's submission of its request for arbitration in 2018. So in the counter memorial, claimants stated the facts as they were at the time of Morocco's breach in 2015. That is all. There's nothing nefarious about this. Now, I think I have made a point with regard to the documents that were raised by respondent earlier today. That is to say that he sought to introduce those documents. These were not new documents. As I indicated, they were part of the record. And so, again, another example about the Morocco's complaints about the sufficiency of evidence on the basis of the fact that they were after the fact, but Morocco is seeking to rely upon a document reflecting the facts as of 2016. They cannot have it both ways. In other words, either the 2017 facts are not relevant, or they cannot have them both ways. And again, I just like to make a brief point that is subject to confidentiality. So if we could ask for the U.S. to briefly leave the room. Okay, just continuing with an explanation of the corporate structure, the Carlyle Group, which was also acclaimed, of course, was and is the ultimate parent of all the other claimants. CCM in particular was an entity within the Global Market Strategies business unit of the Carlyle Group, and it served as the Carlyle Group's exclusive commodities trading platform. So it was clearly involved in the investment and in the structure. So these four claimants were all part of the investment structure. Now I return briefly to the diagram from claimant's opening presentation. It not only reflects all of the points just mentioned, but at a high level, it also shows how the claimants as a whole are clearly connected to one another and to the Cayman investment vehicles. Morocco has repeatedly tried to no avail to separate claimants from the Cayman investment vehicles, cluttering its diagram with distracting boxes of all shapes and sizes and extended lines and arrows, all for the purpose of showing a distorted version of claimant's investment structure. Morocco's version of the corporate structure, however, regards the unity of the claimants, and to further distract the tribunal, wrongfully elevates third parties like the Maryland pension system, the notes trustee, and even the so-called mysterious third party foreign investors in the notes, the vast majority of whom, as I explained on Wednesday, based on record evidence, are actually U.S. investors to further distract the tribunal. To hear Morocco tell the story, the proper claimants here, as I've said before, are a group of retired pensioners, and that is frankly absurd. At bottom, the factual evidence leads to only one conclusion. Claimants and their investment vehicles were all part of the same holistic investment structure that effectuated the investment transactions with Samir. In other words, in addition to the evidence that was already in the record prior to this hearing, Mr. Zouik's live testimony yesterday should doom Morocco's position that it was the Cayman investment vehicles that are somehow the real parties in interest here. Everything that Mr. Zouik said reestablished that without claimants, and CCM in particular, there would have been no Cayman investment vehicles in the first place. Moving on to Morocco's second false contention that claimants made no monetary contribution or other valuable contribution to the investment, the evidence clearly shows otherwise. Mr. Zouik confirmed, and this is should be a slide of his testimony, that the master fund contributed funds into VMFQ's accounts to be used for transactions. And critically, he also confirmed when it did so in the spring and early summer of 2015. In light of this testimony, Morocco's repeated emphasis on the fact that the audited financials were dated as of December 31st really rings hollow. Companies don't create audited financials on a weekly or monthly basis. They are done, of course, at year end. And the idea that somehow we were supposed to have shown more than the audited financial statements, something that would have shown financial statements as of August 7th, 2015, is absurd. What we showed was clearly sufficient evidence coupled with the testimony. And again, the testimony, there is no hierarchy of evidence. The testimony of Mr. Zouik is equally important to the documentation that's provided, and we've provided substantial documentation. We've also shown that VMFQ1 contributed funds to 2014-1 to fund 4 letters of credit for the following transactions: Samir 1011, Samir 1014, Samir 1015, and Samir 1016. Now, in its opening presentation, Morocco refused to acknowledge that claimants' exhibit C61 provided clear evidence of Q1's transfer of funds into 2014-1's account, even though that document showed a wire transfer that was identical or virtually identical to the date of issuance of the letter of credit and the exact same amount of the monies transferred from VMFQ1 and the monies backing the letter of credit. And this slide reflects that. And shows Q1's contribution, which respondent has continued to deny and did so in his earlier presentation. In face of this clear evidence, Morocco deemed this exhibit to reflect no more than correlation linking those two transactions. That is simply preposterous. Now, while we're on the subject of Morocco's accusations that claimants have provided insufficient information concerning the 16 transactions issued, I'd also like to address other misstatements in Morocco's chart setting forth information regarding the 16 transactions, which was Respondent's Demonstrative 3. Respondent makes it seem as if information is missing or has not been provided, suggesting that claimants are hiding information. I've alluded to this before, but again, there's nothing missing. For the bottom 3 entries, as I pointed out earlier, the Samir distillates, fuel oil, and gasoline deals, which are what we have called the swap transactions. No information on letters of credit was provided for very good reason. As claimants explained in the rejoinder, these transactions were not funded by letters of credit, but rather by swapping oil owned by Q1 for refined product. Nevertheless, these transactions still involved initial payments by Q1 to acquire the crude oil in the first place.
I'm sorry to interrupt. Diana, did you get that
I'm sorry.
last part?
I think it would have come through on the audio, but perhaps
Because it wasn't
very
clear to me on the audio. So if you need Mr. Ordway to repeat himself, just let us know.
Yes, perhaps that would be good. Sorry, Mr. Ordway.
No, not at all. Not at all. What I was saying is that, as claimant explained in their rejoinder, these transactions were not funded by letters of credit, but rather by swapping crude oil owned by Q1 for refined products. Is that clear now?
Thank you.
Okay. Nevertheless, these transactions still involved initial payments by Q1 to acquire the crude oil in the first place. Now, during the examination of Mr. Zouik yesterday, counsel from Morocco openly complained that they did not have any of the documents on the swap transactions, and so they were allegedly unable to, quote, do the exercise of understanding how the swaps worked and how Q1's contribution worked. And as the colloquy on this slide shows, however, counsel from Morocco's allegations in this regard were untrue. And my colleague, Mr. Yohai, pointed out that the documentation was in fact produced in the RW documents and is indeed part of the arbitral record. Turning to those now, these are the Samir 1003 and Samir 1006 transaction confirmations under which Q1 owned a total of $76.9 million of crude oil. As part of the swap, Q1 sold this oil back to Samir. And then going to the next slide, in exchange, claimants took title to $76.9 million of refined products pursuant to these confirmations. Simply put, respondents' allegation that claimants have provided no documentations of the swap is just incorrect. And we note that this is another example of how Morocco complains that there is no evidence of a thing, but the problem is they either have not read the evidence or have chosen to ignore it. Let me also briefly address the entity Crimson Physical, which was an issue raised on Wednesday. Morocco has correctly noted that Crimson Physical contributed funding for one of the 16 open transactions, Samir 1020. But there's nothing mysterious here, as I believe I indicated. Crimson was a master feeder investment structure that was set up and managed by CCM, similar in structure to Celadon. In the grand scheme of the investments, this was essentially a one-off and immaterial to the jurisdictional analysis. Claimants have also demonstrated that the money used by Q1 in the commodities transactions flowed ultimately from the U.S. onshore feeder, as claimants have shown through the 2015 audited financial statements, which are in the record at C34. The U.S. onshore feeder invested $184 million in the master fund in return for participating shares. The master fund in turn invested $157 million in Q1 in exchange for participating shares. And Q1 then invested $136 million in the Samir investments, which was noted as a realized loss on the master fund's 2015 audited financial statement.
Let's we are off the record. Give it 2 minutes to the court reporter. You have been very fast now.
Oh, my apologies. My apologies.
Oh, your apologies to the court reporter.
Yes, Ms. Burton, my apologies to you, definitely.
Thank you.
All right. In sum, Morocco is flat out incorrect that claimants made no monetary contribution to the investment. Moreover, to the extent Morocco has argued that claimants made no contribution whatsoever to the investment, that is also false. Not only did claimants contribute millions of dollars of funds, but as has been stated numerous times, claimants also contributed significant investment management expertise from CCM, as well as the commodities themselves, particularly with respect to the swap transactions. The third false contention that I will address is that prior to August 7, 2015, before Morocco took a single action against Samir's bank accounts and took over Samir's refinery, among various other improper actions, claimants' commodities no longer existed in Samir's tanks. As I noted on Wednesday, claimants' evidence clearly shows that oil and product remained in Samir's tanks for many months after 2015, indicating that the unauthorized disposal of claimants' commodities was an ongoing occurrence after Morocco took over Samir's refinery and froze Samir's accounts in August. We have shown multiple independent inspector reports from December 2015 and March 2016, which showed that those tanks still held hundreds of thousands of barrels of product many months after August. And as Mr. Walk testified yesterday, the existence of third-party inspection reports is highly probative evidence and certainly trumps an unsigned custodian certificate that merely shows what Samir pledged, not what it was storing for Carlyle on any given day. Mr. Herring went on great length about this to try to trip up Mr. Walk, but again, this is another red herring. Mr. Walk also testified that his review of the contemporaneous stock tank reports demonstrated the presence of commodities in Samir's tanks both days before and after August 7, 2015. Mr. Walk noted that the commodities inventory shows that both immediately before and immediately after the August 7th government actions, and indeed for many months thereafter, tank reports through to the end of 2015 continued to show substantial quantities of the very same products that Carlyle had purchased. And now I just want briefly to address a matter that is confidential. So I would request that
okay,
the United States leave the room. All right, now I'd like to go to the findings of the New York trial court, which Mr. Harris has referenced both in his submissions and earlier today. These are the findings of a court in an unrelated insurance litigation, which, as I have stated previously, is hotly disputed and currently pending on appeal. Now, just as a comment, Mr. Harris, again, another example of mischaracterization. At one point, I believe he said that that claimants went to arbitration because it was not doing well in the litigation. This is not at all true, and in fact, the decision was quite recent, and one bears no connection to the other whatsoever. Obviously, claimants filed their arbitration in 2018, and this decision was issued in last year. So that characterization is really very inaccurate. And as to the litigation itself, there are obvious factual issues that were not resolved in the insurance litigation, and there's certainly no reason why the tribunal should defer to an incorrect ruling that is currently being appealed by Carlyle. Regardless of the preliminary findings of the New York court, the evidence before this tribunal is that there was no course of conduct here, and certainly no acquiescence by Carlyle, as Morocco's counsel wrongly suggested. The actual evidence, including Mr. Zuek's point-blank testimony yesterday, is exactly the opposite. As he said, they were not allowed to use our commodities without our written consent, and we never gave them written consent to use the commodities. Accordingly, Morocco's contention that there was supposedly nothing for it to expropriate as of August 2015 is yet another baseless assertion that both Mr. Zuek and Mr. Walk refuted through their testimony in this arbitration. The bottom line is this: claimants clearly own commodities at the time of Morocco's breach, and they were clearly owed funds earmarked for Carlyle by Samir. And so Morocco's improper actions as to the disposition of commodities and the proceeds thereof, beginning in August 2015, did in fact destroy claimants' investments and put the nail in the coffin on claimants being able to recover the value of all they lost. Another false fact that I'd like to allude to that Morocco has claimed is that claimants' investment transactions were just repo financings, transactions that don't count as a threshold matter. Claimants reiterate that it actually does not matter what one labels the transactions. There is simply no need to get hung up on debates about labels here because they plainly had the characteristics of an investment, as I will discuss shortly. In any event, Morocco's mischaracterization was emphatically rebutted by both Mr. Zwick and claimants expert Mr. Walk yesterday. As Mr. Zwick testified, quote, when we set up these transactions, they were specifically set up not to be financing transactions. A fundamental aspect of the transactions was that Carlyle would take title to and own the crude oil and refined products. The fact that the investment transactions with Samir were true sales of the commodities was plainly reflected in the MCTA between claimants and Samir and acknowledged by the Moroccan Foreign Exchange Office in its official approval of the arrangement. It was also affirmed by Samir on multiple occasions. And because claimants outright owned the oil and refined products, claimants were responsible for arranging for the storage of those commodities. And they also had to obtain insurance. In short, the arrangement between Carlyle and Samir was not a short-term loan involving collateral. Far from a short-term relationship, it is now entirely undisputed. The parties clearly intended to have a relationship spanning at least 3 years. As Mr. Zwick testified, the long-term nature of the arrangement was critical to Carlyle because it used Samir's promise of a long-term deal to raise and secure capital from its investors who were seeking to purchase long-term debt instruments. Accordingly, Carlyle planned to continue the relationship even beyond the 3 years stated in the commitment letter. And Mr. Zwick also explained why the relationship was truncated: the wrongful actions of the Kingdom of Morocco. Another fundamental aspect of the transactions, which Morocco does its best to ignore, was claimants' put right. Unlike a mere repo financing arrangement, claimants had no obligation to sell the commodities back to Samir. As Mr. Zwick and Mr. Walk each expressly testified, claimants indisputably had the option to sell to someone other than Samir. In fact, in sum, I should say, Morocco's self-serving and severely misleading version of the facts here cannot serve as a credible basis upon which this tribunal can apply its interpretation of the FTA. There are simply too many false premises, too many conclusory statements that have now been refuted, and too many distractions that ultimately amount to nothing that detracts from their unequivocally being jurisdiction present here. Now I return to Morocco's 3 remaining objections by once again noting the 2 provisions of the FTA that are at issue in these objections, the definition of investment in FTA Article 1027 and the definition of investor of a party in the same article. And to recap, investment is defined very broadly. It covers every asset that an investor owns or controls directly or indirectly that has the characteristics of an investment, including such characteristics as the commitment of capital or other resources, the expectation of gain or profit, or the assumption of risk. Investor of a party is defined to include an enterprise of a party that concretely attempts to make, is making, or has made an investment in the territory of the other party. Now, not only are claimants' claims properly brought under Article 1015(1)(a), for the reasons discussed at the outset of this presentation, the commodities and contractual rights at issue are covered investments under Article 1027 because they are assets bearing the characteristics of covered investments, and they were owned and or controlled directly or indirectly by claimants. Therefore, Morocco's objections number 1 and 2 should be rejected. Claimants are covered investors under Article 1027 because they made the investments in the territory of Morocco. Therefore, Morocco's objections numbers 2 and 4 should be rejected. I briefly address each objection in turn. The first objection contends that claimants' investments are not covered under the FTA and the ICSID Convention because they do not satisfy the so-called Cellini test. As I explained in my opening presentation and discussed, and as were discussed in claimants' papers, the Cellini test is not dispositive, but even the so-called Cellini test, if it were to govern the analysis, claimants' investments would satisfy it. Again, keeping in mind the unity of the investment principle, and particularly, I will not repeat the extensive law in support of claimants' position as to each of the factors, but I note the following. As explained in my presentation, both the evidence submitted to date and Mr. Zuik's testimony make absolutely clear that claimants did, in fact, commit capital and other resources, namely CCM's deep investment management expertise and commodities, particularly with respect to the swaps. The origin of the funds, as we have noted on several occasions, per well-established principles of international law, does not matter. So Morocco's various arguments about the original source of the funds that the U.S. onshore feeder entity used or that CCM directed to make the investments at issue are moot. Also, as noted earlier, with regard to duration, the intended long-term nature of the arrangement with Samir, which, as we've said many times, is at least 3 years, was a key aspect of the investment. And for the reasons identified too by Mr. Zuik, it is the intended length of time, not the actual length of time, especially when cut short due to sovereign interference, that matters under international law.
Mr. Ordway, the secretary advises me that you are 1 hour 35 minutes. Take your time so that you have
thank you.
Of how you
Yes.
are going.
If I may, I do think I have a little bit longer. It may be as much as 10 minutes, but I will try to make it as short as possible.
Very good. But don't run, because if you run, then the transcript becomes impossible.
Understood. Thank you. The final factor, of course, is assumption of risk. And there was risk here. In fact, I believe at one point in the presentation earlier, Mr. Harris referred to these transactions as risky transactions. So there clearly was risk here, risk of physically losing claimants' commodities, the risk that the commodities would decline in value should claimants be forced to sell to a party other than Samir, and sovereign risk. And claimants also reiterate that, as Professor Schroyer has stated, the very existence of a dispute is seen as an indication of risk for purposes of international law. And indeed, they are here before the tribunal seeking recovery of hundreds of millions of dollars in losses. Moreover, of the Cellini criteria, that of risk perhaps has been applied the most laxly by ICSID tribunals. And we have noted that in our papers. Accordingly, Morocco's first objection must be dismissed. Morocco's second objection has two parts, which purport to undermine claimants' standing as covered investor. First, it claims that claimants did not own or control the investments. That is rooted in the definition of investment. And second, it contends that claimants' investments were not in the territory of Morocco, which is rooted in the definition of investor of a party. Both are easily refuted by the evidence and applicable law. To start with the first part, as claimants have explained, claimants have ownership interests, full stop. As noted earlier, this has been made abundantly clear through Mr. Zuik's testimony concerning the U.S. onshore feeders' participating shares in the master fund and the master fund's participating shares in Q1, as well as the fact of TC Group and TC Group Investment Holdings limited partner interests in both the U.S. onshore feeder and the offshore feeder, and the Carlyle Group's ownership interests of those claimants in turn. The existence of the sleeve transactions do not change this fact, since, as I explained earlier, there were commodities held by Q1 that were never sleeved to 2014-1. And as an overarching principle, where title lay among the various vehicles at a specific moment in time is not determinative of anything, since CCM controlled the investment activities of all three vehicles, and they were all part of the unified investment structure at all relevant times. Now, before I move on to claimants' control of the investment, I just want to respond to respondents' invocation of Emis versus Hungary and the idea that Moroccan law is dispositive of the determination of claimants' ownership interests. To start, contrary to Mr. Harris's statement, the decision number 176, which he showed to the panel, dated February 13th, 2017, rendered by the bankruptcy judge, did not rule that Carlyle never had title to the commodities. What the court found was that any claim to ownership at that juncture in 2017 was not substantiated in a way that will allow recovery of the commodities at that time. In fact, the court in both first instance and appeal never explicitly considered that Carlyle never owned the commodities and never conducted a reasoning based on that idea. Even assuming arguendo that it did say that, which it didn't, it still is not dispositive of the issue of whether Carlyle had title to the commodities, because under Article 1021.1 of the FTA, the law applicable to claimants' claims is the FTA and international law. The laws of Morocco have no binding effect on this tribunal, and the tribunal need not evaluate the issue of ownership of the commodities in accordance with Moroccan law. And in that regard, the case of Corona Materials versus Dominican Republic was a case under DR CAFTA, which contains an identical governing law provision to Article 1021 of the FTA. Just as Article 1021 of the FTA does, Article 1022 of DR CAFTA designates the agreement, that is DR CAFTA, and applicable rules of international law as the governing law of disputes under DR CAFTA, Article 1016(1)(a), which, as discussed with respect to Capis versus Guatemala, is identically worded as FTA Article 1015(1)(a). On that basis, the tribunal found that the role of domestic law in the arbitration, if any, is marginal. So the award on Emis versus Hungary, based on that, does not support Morocco's argument that the tribunal should look at Morocco's law to determine the issue of ownership. And by the way, the facts in Emis are also significantly different from the present case. In Emis, a case about the rights to broadcast commercial radio frequencies in Hungary, the parties actually agreed on the application of Hungarian law to the nature of the claimant's rights. So the parties are agreed that the nature of any rights that might form the basis of claimant's expropriation are to be determined under Hungarian law. That's what the basis for that case was. Even assuming that Moroccan law were dispositive, though, we do not believe that it should be followed, because the court incorrectly relied on the standard integration clause in the forbearance agreement to say that it somehow did away with Carlyle's rights under the MCTA and CSA, which in fact the forbearance agreement expressly affirmed there, and the fact that Carlyle filed a debt declaration in the Moroccan bankruptcy proceeding, which it had to do in order to protect its own interests, to then support its judgment and to consider that the Carlyle entities should thereafter be treated as creditors who could not recover the commodities. In any event, we do not believe that that case should be given any serious consideration for the reasons that we have set forth. Turning now to the issue of control, as I noted earlier, Mr. Zuick reaffirmed CCM's incontestable control over the investment Indeed, all of the testimony that we revisited moments ago, the plain language of the investment management agreements and the portfolio management agreements, the fact that the investment vehicles were devoid of any employees and that CCM was the only point of contact for Samir, and even the Moroccan government for that matter, and Mr. Zouik's firsthand experience running the investment transactions, that is more than sufficient evidence of CCM's control. The fact that the sources of CCM's control was contractual rather than ownership-based makes no difference under the FTA, which contains no definition of control, much less one requiring an ownership interest. Now, during Morocco's opening presentation, and also in its earlier presentation today, counsel for Morocco claimed that to the extent this tribunal were to recognize de facto control, as the Thunderbird Gaming versus Mexico and BMEX tribunals did, claimants would have to prove such de facto control beyond a reasonable doubt, quoting the Thunderbird Gaming case. Claimants disagree that such a heightened standard of proof is required at the jurisdictional stage. I've said that earlier, and I reiterate that. The law is clear that the applicable burden of proof is a preponderance of the evidence. For the reasons stated, claimants believe that the factual evidence concerning CCM's absolute control over the investments is extremely strong. As explained in claimant's submission and again on Wednesday, CCM can unquestionably be analyzed to claimant S.D. Myers in S.D. Myers versus Canada. It controlled every decision, every investment, every move with respect to the investments at issue. We know that that Mr. Harris doesn't like that case, and as is the case very often where a result is at odds with his desired conclusion, he said it was wrongly decided. We disagree because claimants, we believe, are analogous. We believe that claimants did in fact own and control the investments. The first part of Morocco's second objection, therefore, is meritless. I'm only a few minutes away from wrapping up. With respect to the second part of Morocco's second objection, the in the territory issue, I will not belabor this point since Morocco already has conceded that the commodities were in the territory of Morocco and that the CSA was governed by Moroccan law. But to the extent Morocco has argued and continues to argue that claimants' other contractual rights, and namely the put right in the MCTA, are not in the territory of Morocco, claimants respectfully refer the tribunal back to their papers on this issue, including Professor Schroer's legal opinion submitted in this proceeding. And only note once again that pursuant to the unity of the investment principle, claimants' contractual rights simply cannot be analyzed separately from the commodities themselves. And as an intangible asset with no physical presence, by nature, what matters under the applicable law is that claimants' investments clearly benefited Morocco by servicing its sole refinery with a reliable supply of fuel and crude oil and creating jobs. Therefore, the second part of Morocco's second objection is also completely meritless, and Morocco's second objection overall must be dismissed. And then finally, and briefly, Morocco's fourth objection advocates for the application of an active investor requirement and seeks to disqualify claimants, namely Celadon Partners, TC Group Investment Holdings, and the Carlyle Group on that basis. As noted in my opening presentation, though, there is simply no such thing as an active investor requirement under international law, and one should not apply one here where it is plainly sufficient pursuant to the definition in Article 1027 that the investment at issue be owned or controlled directly or indirectly, and there is no indication as to any requisite level of activity in any aspect of that article. Now, Morocco has relied upon the Standard Chartered Bank versus Tanzania case in support of its position on a purported active investor requirement. And claimants explained once again on Wednesday why that reliance was misplaced based on various legal distinctions and factual distinctions. Now, one of the questions that was asked by the tribunal They asked the parties to advise on how subsequent tribunals have treated Standard Chartered Bank. Now, before I go to this slide, earlier today, Mr. Harris said that we should refer to the cases in his reply that dealt with that. Well, frankly, though the cases that were referenced by Mr. Harris in the reply really did not follow Standard Charter, and that's the key point. Claimants represent that their survey of the case law indicates that in the majority of cases touching upon a purported active investor requirement subsequent to the Standard Chartered Bank decision, the tribunals ignored that decision. And in the few other cases that you see in the slide before you, the tribunals briefly discussed, but ultimately distinguished Standard Chartered Bank. For example, in Bernhard von Petzold versus Zimbabwe, the only one of the four that involved similar treaty language, the tribunal rejected the argument that the BIT required an investment to be actively made, as opposed to just passively held. So although the tribunal referred to Standard Chartered Bank, it found that it was distinguishable both on the facts and the wording of the BITs, and thus did not provide reliable authority. To claimant's knowledge, and again, this is based on the work that has been done in the last 48 hours, there is no case that we have found in which a tribunal has relied upon and followed the Standard Chartered Bank decision. Accordingly, to sum up claimant's response to Morocco's fourth objection, there is no doubt that claimants collectively made the investments at issue, and none of the sparse case law put forth by Morocco, least of all Standard Chartered Bank, alters that reality. Therefore, Morocco's fourth and final objection must be dismissed. In closing, for all of the reasons just stated, although claimants have clearly sustained their burden of proof and sufficiently addressed Morocco's four objections, Morocco has not met its burden of proof as the objector. None of Morocco's objections are well-founded. The tribunal must reject Morocco's unfounded reading of extraneous extra-textual requirements into the FTA's standing provisions. And it must also reject Morocco's inaccurate and misleading rendition of the key facts. As a final note, I return to where I began on Wednesday, and this is a point that Mr. Harris objected to or saw as inappropriate. It should be eminently clear to the tribunal that Morocco wants to escape responsibility for its wrongful actions against claimants' investments in Morocco, but states must be held accountable for their actions against investor, and that is what this treaty requires. And where claimants are the only ones with recourse in the arbitration, they should simply be given an opportunity to have their case heard. That is all that was meant by the comments that were made in our opening. And on behalf of claimants, I thank the tribunal for its time and attention to this matter and remain at your disposal for further questions.
Thank you, Mr. Ortway. We have now a break before we then have two short rebuttals. And it says 15 minutes, so it's now 1955, 56, 50. So let's come back at 2015, 2015 and whatever time it is in the other parts of the world. We have then a 20-minute respondent's rebuttal, and then a 20 minutes claimant's rebuttal, and then we have to wrap up. So I would kindly ask both of you, let me get a time check for you, Mr. Ortway.
1 hour, 51 minutes, and 56 seconds.
Can I kindly ask you, Mr. Ortway, that you stick now to the time, to the 20 minutes that you have, because otherwise we will get into a very, very long session.
We agree completely. We will do so.
Very good. And thank you. So we will be back in a quarter of an hour at 20:15. Thank you.
Thank you. Great. I think we're all back.
Thank you. Thank you very much, Ms. Rosenberg. We now continue with the hearing, and I give the floor to respondent to make its rebuttal presentation.
Thank you very much, Mr. President. I'm going to start with objection 3, and in the interest of being efficient, I'm going to just go through and respond to some of the points that Mr. Ordway made. But in relation to objection 3, there are really 2 fundamental points that you need to take into account. Firstly, contrary to what Mr. Ordway kept on saying, we are not trying to read the word direct into the treaty. What we are doing is interpreting the words on its own behalf that are in the treaty. It's quite important. And that's what Mr. Ordway makes no attempt to do seriously. And the second point on objection 3 is that you will have noticed, you'll have been struck, I hope, by the fact that Mr. Ordway completely failed to address you on the points on Article 10.25 and 10.17 of the treaty in giving meaning to on its own behalf. And those are 2 really, really important points. Now, picking up some other points, Mr. Ordway started by making points about the primacy of the FTA text in the interpretation of a treaty, and he referred you to the ILC commentary on that the text must be presumed to be the authentic expression. But as I showed you in opening, the same ILC commentary, the ILC says a subsequent agreement is part of the text of the treaty. And that was in our earlier slides. Mr. Ordway says, well, if the US wanted to preclude recovery of indirect losses, they should have put different language in. And they should definitely have done it when they saw 6 NAFTA tribunals rejecting the same argument that I now raise. But that's just not true. That's a straw man. The NAFTA tribunals he refers to in his briefs did not reject the same argument that I'm making. And you feel free, go and look at those cases. You will not find a single mention of Article 10.25 or Article 10.17, the rationale, the whole underlying argument that I raised. It's just not dealt with. Mr. Ordway then said, well, if the treaty's silent on direct or indirect, that's in favor of the claimants. Well, point 1, it's not silent on it if you interpret the treaty properly. But point 2, even if it were silent on it, Mr. Ordway's forgetting the fundamental proposition that the customary international law of Barcelona Traction then applies, unless he can satisfy you that the treaty expressly contracts out of it, which it clearly doesn't. Mr. Ordway addressed you repeatedly on the effet utile argument, but unfortunately he directs it to the wrong point. The effet utile argument is not about 10.15, it's about 10.17 and 10.25. Those provisions have no meaning, as I explained to you in my closing submissions earlier, on Mr. Ordway's interpretation, because an investor just brings its claim for the company's losses and completely circumvents 10.17 and 10.25. And that is a fundamental flaw in his argument, and he has no answer to it. Now, Mr. Ordway then made reference to Mr. Gazzini, Professor Gazzini's book, and he talked about the fact that we were getting it wrong because it's only these formal mechanisms that you can use, and he expressed the view that Professor Crawford had taken that view, but I'm afraid the claimants have just misread and misunderstood what is being said there. All that is being said, to be clear, is if you have a joint committee decision in the NAFTA context, that decision, or here under the treaty mechanism, that decision is automatically binding. But where you have an Article 31.3a agreement, that, as I said earlier, and Professor Gazzini says that in his book, that agreement goes into the interpretative calculus where it has determinative weight, in my submission, but in his evidence, very substantive weight. Mr. Ordway then said, well, there's no consistent practice, but on this particular provision, because there haven't been claims brought under this treaty before. But I mean, that's just an absurd argument. If you say that the same language has been used in umpteen US FTAs, and in every single case, the US and every other party to those treaties, when they've been called on to say anything about it, has said this is what it means, that is plainly practice relevant for the purposes of the language. But in terms of that's only going to practice in any event. That's not 31.3a, that's 31.3b. 31.3a on the agreement, Professor Gazzini is very clear, and I showed you it on a slide earlier, that such agreements can be formed by disputing and non-disputing party submissions. He says that expressly. And ultimately, where Mr. Ordway's argument came out is where I said it would come out. This is all terribly unfair. We didn't look at the history of this language. We didn't look at the NAFTA cases. We didn't look at the other FTA cases. All we looked at was the FTA. Well, okay. But as I said earlier, if you misread a treaty, and if you don't do your research, you can't then say to the tribunal, well, just ignore what the treaty means, ignore what the two treaty parties tell you it means, their agreement, which you have to take into account under Article 31.3. Just ignore that because we didn't get that. We misunderstood. This is very different, and it's important for the tribunal to understand this is very different. This is nothing like a sort of ACMEA position where an external body comes afterwards and says the whole treaty's over. This isn't that. This is an agreement between the treaty parties as to what the language has always meant in the treaty. And it's a point that has been argued in front of a number of tribunals for 30 years by the US and for 20 years by, 15 years, 17 years by the various other parties. Mr. Ordway kept on saying that we were trying to amend the treaty. As I've expressed to you already, we're not amending the treaty. We're not reading in the word directly. We are interpreting what that language on its own behalf means, and you have to give meaning to that language. And that includes the language and policy language underpinning 1017 and 1025, to which he's got no answer. And don't forget that even as outside of the express treaty language, it's not an uncommon or an unknown position, because there's the Postova Banka line of cases, of which there are numerous, Karki in Pakistan, etc., where the same position is taken, that an investor cannot claim in respect of damage to the assets of its subsidiary. And that reflects the Barcelona Traction Rule as well, and it applies as a matter of general law, we say. But here we've got the specific treaty language as well. I've addressed you on Mikkeler and why that's a completely different point, because the Mikkeler cases don't have a requirement to identify direct loss in the way that our case does. Now, on the facts, Mr. Ordway made a lot of points on the facts. He said, you know, Mr. Zuek, you'll have noted most of the slides came from Mr. Zuek's set piece, which is, I think, rather appropriately actually in the tribunal procedural order timetable described as a presentation. What Mr. Zuek, and they rely on that a lot, what Mr. Zuek said, well, Q1 had no employees or premises. well, okay. But as he also accepted, it had separate legal personality, it had a board of directors, and it had accounts. And it's plain wrong of Mr. Zueck to say that the directors had nothing to, it's plain wrong, sorry, to say that Mr. Zueck said the directors had nothing to say, because he accepted in cross-examination that the management agreements were revocable and were specifically drafted and on very precise terms, as I showed you and showed him. Then we have this interesting position that we still have this complete contradictory position about whether it's the management shares, the ownership that matters, or whether it's the economic interest or the legal interest. We still have no answer to who the management shares are held by, and no answer to that complete contradiction in their case. When it comes to Q1, what matters is the participating interest. When it comes to the other entities, what matters is who's the general partner who's got the legal interest. Now, in relation to the onshore feeder, Mr. Ordway makes his point, well, the onshore feeder had all the economic interest and the management interest isn't relevant. And the management share interest isn't relevant because they have no say. And he put up a slide 43 of his presentation, and you can look at it in your own time. But even on that slide, it says that the management shares participate in a winding up. It's a curious suggestion that they have no economic interest if they participate in a winding up. But leave that to one side. He said Mason fully supports his position because that case found that the general partner had standing because it had a beneficial interest. Yes, it did find that, but it also found, and actually is the primary finding, that the general partner had the legal ownership because the entity in the middle was not, as here, a limited company, but was an LP which had no legal personality and couldn't hold the shares. Then when we come with Maryland, he said Maryland had no authority to control the investment vehicle. So you forget Maryland. It has all the economic interest, but you don't look at Maryland anymore. Same structure. And he said it was frankly absurd to suggest that the entity with the economic interest is the real investor. I just don't follow. Then we have this position of Mr. Zueck. Mr. Zueck said in direct, very heavily relied on by the claimant, said in direct that the payments were made in spring and summer of 2015, slide 50. And you'll recall, Mr. President, that this is precisely the point I made at the procedural conference, that what we were going to get was new evidence. Contrary to paragraph 2210.3 of the P01, and you confirmed it to them at the procedural hearing that it's not okay to adduce new evidence. Mr. Zueck had the last word. He had his third witness statement with their rejoinder. And the first time it is ever suggested in this arbitration that the money was transferred from Q1 in relation to these investments to Q1 in relation to these investments in spring and summer of 2015 is in his set piece presentation. Nothing new happened after his third witness statement, except that we made the point for about the 50th time in our opening. And sure enough, the next day, this evidence comes. We say that evidence should be disregarded. But even if you don't disregard it, it's utterly hopeless. They have still not made any attempt to explain why they have not produced the bank transfers. This is all, according to them, these are all their structures. Even now, they own them all, they control them all completely. Mr. Zueck, the CCM has absolute control over everything, but he can't produce a bank statement showing a funds transfer. And that's not a question, as Mr. Ordway confuses it, of origin of funds. It's not a question of origin of funds. We're not talking about that. What we're talking about is the claimant, each claimant has to show that it directed or transferred some funds, that it did something. I don't care particularly for those purposes where those funds come from, if they borrowed them or whatever. That's the origin of funds point, but they have to show that they did something with them. And that's what they haven't shown. On the swaps, it may be my fault, and I'm perfectly prepared to accept that. But I'm afraid there seems to be a misunderstanding of what our problem with the swaps position is. What we don't have is the letter of credit or confirmation in relation to the underlying transaction before the closeout. We cannot see who was the consignor of the original oil or who funded the original oil products. All we're shown is a closeout. But if the original oil was owned by 2014-1, like in every other transaction we've seen, then 2014-1 and State Street Bank had the proprietary interest. And that's the point. Now, Mr. Ordway asserted, in my note, it was at page 146, line 3, that the claimants contributed the oil under the swaps as a contribution as part of his investment case. But there's just no evidence of that. And that's my point. Giving us the closeout doesn't tell us anything because you don't know who owned the oil that was being swapped. We've got the Crimson structure, which is, you know, we've referred to it in our briefs. It's another third party providing financing that we know nothing about, the claimants never told you about. It was then said that Mr. Walk testified that the existence of the third party tank reports certainly trumps unsigned custodian certificates. But that's not what he testified at all. Let's look at his answer in cross-examination to me. He accepted earlier that the tank reports did not say who owned the oil at all. And he accepted that the documents were irreconcilable. He hadn't tried to reconcile them. He doesn't know how to reconcile them, and that the information being given was completely contradictory. The only difference between the two is that one is supposed to be directed specifically to Samir. The New York court findings, according to Mr. Ordway, they're the preliminary findings of the New York court. I suspect that would be news to the justice who rendered the binding and final judgment. The fact that it's on appeal is completely irrelevant unless and until that appeal succeeds. But how he can say our allegation is baseless when it's been held by a New York court after hearing the evidence, I'm not quite sure. And he says, well, Mr. Zuek says it's not right that there's any consent, but we've put on the slide. Put on the slide the extract from the submissions made by Mr. Yohai in New York, completely clearly saying that Samir stole the oil. And let's look at what Mr. Suvagia said in New York. This is an old slide, so it's not the highlighted text, it's the top line. My question was that processing done with Carlyle's consent? Answer, I believe there was implied consent. That was Mr. Suvagia. And it's on the basis of that deposition testimony that the New York court made one of its findings, that the claimants knew about it. Now, you can't change what he said, and we can't give you the actual deposition because Carlyle refused to give it to us. The one that's publicly available is redacted, and they refused to give us the unredacted one. And likewise, we don't have the unredacted version of Mr. Zuek's deposition. But you can see, at least in that document, what Mr. Suvagia's evidence was. Mr. Ordway said, we're hung up on labels, calling this a financing, and you don't need to get hung up on labels. Well, 2 points to that. One, they seem to be far more hung up on it than we are. But two, it obviously matters a great deal because, as I explained in opening, if, as we say, this is a financing, it makes a difference to which chapter of the FTA the claim is under. And that matters. Now, then Mr. Ordway said, well, these were long-term transactions. I'm not sure how he gets to the point that's undisputed. I explained clearly why it's disputed. And he relied again on that same document to say that it's undisputed that they're long-term. That one-sided, non-binding on CCM document entered into after 13 of the 16 transactions have been entered into. I've explained the origin of funds point. And then Mr. Ordway says, well, Mr. Harris has admitted that there was risk. He said it was risky to trade with Samir. Well, yes, I did say it was risky to trade with Samir, but that just completely misses the point. The point is who bore the risk? Did any of the claimants bear the risk? No, they didn't. 2014-1 took a lot of risk. On the claimant's case, Q1 took some risk. But not the claimants. They didn't take any risk. They specifically created a structure to avoid them taking any risks. Mr. Ordway said, EMIS doesn't support our argument that you should look to Moroccan law to determine ownership. So which law do you look to determine ownership of commodities in Morocco? International law doesn't tell you anything about property rights. And that's what the EMIS Tribunal says, and it's a fairly standard provision of international law. And then he said, well, and you definitely shouldn't apply Moroccan law because the Moroccan court got it wrong. But this tribunal isn't a court of appeal of Moroccan law. It's in no position to second guess the Moroccan court's determination on this point. Turning to control now, finally, Mr. Ordway said, source of control makes no difference under the FTA. But that's just not right. It's striking, members of the tribunal, that still now, in my rebuttal closing submissions in this hearing, there is no answer from the claimants to the point that on their interpretation of the FTA, the CEO of the company, with his employment contract, can bring the claim under the FTA as the investor. Because he, on their analysis, controls the company. And on their analysis, remember, that CEO can bring the claim for the entire loss of a company 3 down the chain. It's a striking failure to answer that point. It is an unreal interpretation. It just doesn't bear any relation to reality. That somebody who is simply exercising a contractual power of control, has some contractual power of control, suddenly becomes an investor who can claim on behalf of the company in the way that they suggest. He refers to the SD Myers case and said, I've got no answer to it. I gave you the answer to it in opening. It's a very simple point. They're very odd facts. To the extent I would need to say it's wrong, I could say it was wrong, but ultimately, Dana Myers in that case exercised control because he owned a portion of Myers Canada. So it's consistent with what I say. And then we had the argument which was made in opening that somehow the claimant's actions were altruistic or otherwise benefited Morocco. But don't forget, this is a transaction, a private commercial transaction between a commercial entity in the US through multiple Cayman Islands subsidiaries and a Moroccan private entity. So if a Cayman Islands entity sells apples to a Moroccan supermarket, that's benefiting Morocco apparently, and that should be taken into account in the jurisdictional calculus. We just say that's wrong. 2 final points. He said no active investment requirement in international law. Well, I don't accept that, but ultimately doesn't matter. There is an active investment requirement in our treaty, and you've not heard any answer to that. Final point, he said the claimants collectively made the investments. I noted the language on his final submissions. Claimants collectively made the investment, and that's the point I made earlier. That's the unity of investor, which doesn't exist. That's not unity of investment. That's unity of investor, and that doesn't work for the reasons I explained earlier. So I've tried to stick pretty closely to my time, and unless I can assist you, that's what I wanted to say immediately now.
Thank you, Mr. Harris, also for sticking to your time, and we will, in accordance with our schedule, we will now give claimant the opportunity for its rebuttal, and then there will be a couple of questions from the tribunal, and then we will have to wrap up. So that should be the development of our hearing. So, Mr. Ordway, are you ready, or do you need some time? Would you need 5 minutes to collect your thoughts? I mean, it is not in the procedural guideline, but if you need 5 minutes, I mean, of course.
I would appreciate just 5 minutes. It will shorten my presentation, which I
know. I don't know why it is not here, but I would always say that there should be some time just to make the notes so that it is more efficient. So now let's break for 5 minutes. It's 20:44. So let's break till 20:50, and then we come back.
Thank you.
Mr. President, I think everyone is back now.
Thank you, Ms. Secretary. But before I forget, I did forget that we had to give numbers to the presentations, both of Mr. Harris and of Mr. Ordway, and I think they should have been H7 and H8. H7 and 8. And then, Mr. Harris, I think you made a short presentation now with your rebuttal, and that should be then H9. So, and if Mr. Ordway presents any document now, it should be H10. Very good. Mr. Ordway, you have the floor.
Thank you, Mr. President. I want to say at the outset that, again, there are a number of points here. I am aware of my time limit and will not only try not to exceed it, but try to make it shorter. However, I will say that I may, as a result of the number of points made, reserve the right to, at some subsequent time, be in a position to comment on some of this, because some of it was raised for the first time, some of these points. In any event, let me start by saying that the two fundamental points that Mr. Harris made, I think really were mischaracterized, or let it maybe put it a different way. He claims that we have said that they're trying to read words into the treaty, and he said, no, that's not the case, that we're trying to interpret the treaty. But our point is, whatever you call what it is that a respondent is trying to do, the effect of respondent's interpretation is essentially to read into the treaty certain language. So it's not as if we have said that they've said it's an amendment. All we're saying is that the effect of their interpretation of the treaty would be to amend the treaty. Now, he's cited 1025 and 1017 of the treaty as examples that support his position. Again, we are not familiar with the decisions on those provisions. We have a different view of the extent to which they affect the treaty in the way that he does. But given that this is another issue, we may reserve the right to address that. Our position is, though, that essentially it is to ignore 1027, which expressly references directly or indirect investments. Now, Mr. Harris made a point about the ILC and said that and referenced the fact that a subsequent agreement is to be considered and should be considered a part of the text. But again, our position is very fundamentally that there was no subsequent agreement, and that there was no subsequent agreement precisely because what happened and what you saw as between the United States and Morocco in this proceeding should not and cannot really be qualified and categorized as a subsequent agreement. Also, Mr. Harris basically addressed my comment that silence is of benefit to claimant in terms of reading the treaty provisions, but there's much more to our provision than simply saying silence. I mean, basically, it is true under the Vienna Convention that you're not supposed to read language into the treaty that is not there, and that's very clear, and the waste management case makes that very clear. But there's more to our position than simply relying on the absence of words, because we have relied, as I said, on provision 1027, which expressly references direct or indirect investment. And our position has been you cannot have an indirect or indirect investment without having a direct or indirect investor. There was a reference that Mr. Harris made to Crawford, Professor Crawford, and to how we have allegedly misread Mr. Crawford. Again, we disagree with that as well. The reference that was made, my understanding of the reference, is of agreement, of a type of agreement, but that was, as in the case of Gazzini, was made pursuant to the formal mechanisms that are an issue, which is not what happened here. As to the case on the points that Mr. Harris made on Emis versus Hungary, again, it's well known that decisions of domestic law have marginal relevance in the investor state, in the investment law context. And Professor Schroer has submitted opinions in which he has identified a number of cases that say that. Now, to some of the factual points that Mr. Harris said, he claims that Mr. Zuick admitted that CCM did not have, that it did have separate personality and a board of directors. And again, indicia in his view of the fact that there was less control. But the point was that the board of directors delegated their authority, and the clear language of the agreements that CCM entered into showed that they had complete control pursuant to those agreements, which Mr. Harris really seeks to avoid mentioning. Also, he mentioned our comments with regard to Maryland and with respect to economic interest. And he says, well, but what about their economic interest? Well, the point that we've been trying to make is that once Maryland made its contribution, those funds became part of the onshore feeders funds. And essentially, once that happened, they were the funds of the onshore feeder. And as the case law that we've cited shows plainly, the origin of the funds is irrelevant. He makes a point about Mr. Zuick, in fact, that with respect to the transfer of the funds in spring and summer of 2015. And again, he seeks to fault respondent for failing to provide significant evidence. And that is just not the fact. We have provided the evidence. Mr. Zuick has provided the evidence in testimony, and to expect somehow there to be, as I've said previously, some financial statement that shows the transfers that he would like to see is unreasonable. We have provided sufficient evidence. And we certainly haven't withheld anything. And what has to be understood here is that these entities do not exist anymore. They were phased out. And that is an important factor in this, because for him to, he said, we've not said that they don't exist. Well, the fact of the matter is it's very difficult to find some documents in this kind of situation, but that shouldn't preclude claimants from being able to assert the claim based on the evidence we have, which has been submitted in good faith, and there's been no attempt to withhold any evidence whatsoever. This is not some subterfuge in which we have attempted to mislead the tribunal or mislead respondent. We have provided all the evidence that we feel is necessary, and respondent keeps coming back and say, oh, well, that's not enough. What about this? There's no document here. Oh, and there's no document here. Again, at this stage of the inquiry, it's a jurisdictional inquiry. We have submitted plainly sufficient evidence to establish a prima facie case of jurisdiction, including those clear prerequisites, which were assumption of risk, contribution, and duration. There should be no question of that. With respect to the swaps, we have indicated that there is no letter of credit associated with them. So he's asked for the letter of credit for the underlying transactions. Well, again, in many cases, what we've heard from Mr. Harris is that statements suggesting that he's asked for these things many times. Well, that is simply not the case. With respect to Mr. Walk's testimony concerning custodian certificates, and he seeks to, in my view, misrepresent what Mr. Walk's testimony was. When he was shown on redirect the document, he basically affirmed that there was more reliability, and it was his understanding that there was more reliability in the transaction confirmations than there was in the custodian certificates, and that's something that he fails to mention. With respect to the New York insurance litigation, Mr. Harris said that my statement with respect to his statement being baseless. Well, what I said was baseless was his statement that the insurance litigation, difficulties in the insurance litigation led to the bringing of the arbitration. That's what I said was baseless. And it is baseless because there's absolutely no support for the notion that claimants turn to the arbitration because of what happened in the litigation. Far from it. And those have to be viewed separately, because not only does claimant has a right to bring an insurance claim, and that's expressly in the FTA, but the two are really very different in purpose and very different in nature. The statements that were made, he said that we refused to provide respondents with Mr. Suvagia's deposition or an unredacted version. Frankly, I do not recall ever seeing a specific request for that. So the idea that we did not affirmatively provide it, I did not see a request for that. Okay. Mr. Harris made some really puzzling comment about how my comments with respect to the benefits to Morocco were some kind of attempt to show the altruism of claimants. That's not the point at all. The point there was to demonstrate that under the relevant standard with regard to in the territory of part of the treaty, what has to be shown or can be shown is whether the state itself benefited from the investment. And that was the point. There was no attempt to ascribe any kind of altruism to claimants, but rather to show that claimants have satisfied the requirement. There was also some reference to the CEO of a company being able to bring a claim under the FTA. What we have stressed is the rights of CCM to bring claims under the FDA by virtue of the fact that under the treaty, they qualify as an entity that had control, sufficient control under the treaty. And furthermore, that's augmented by the contractual rights that we've referenced that CCM had to act as if it was in possession of all of the properties and all of the rights to exercise and seek remedies. The fact that Mr. Harris said that with respect to claimant's position that there is no active investment investor requirement, we do not accept the position that Mr. Harris has taken and the respondent has taken, that there is an active investor requirement. Quite to the contrary, we think the language of the treaty, as we have said, does not show that at all. And it's with respect to the idea of the unity of investment, our position is naturally the unity of the investment does apply to the transactions, but it also applies and has to necessarily to the structure of the entities through which those transactions are made. There is no way of avoiding that if you're going to take the unity of the investment into account, you have to take into account the transactions through intermediate entities. So logically, the unity of investment principle must include the notion of which intermediate entities that investment flows through. I also would like to note that at one point, with regard to the whole issue of whether these transactions were financing or not, Mr. Harris referenced that this could not be qualify under the FTA because of Chapter 10. Well, that is incorrect. It's Chapter 12 of the FTA, which governs, and there's no prohibition whatsoever in terms of seeing these transactions, were they to be considered financings, to qualify. And again, our position is that these transactions were not financing, but the statement that they wouldn't qualify based on the fact that they don't qualify under Chapter 10, that is simply incorrect. Just a few other points. He said that there is no record of Q1 owning oil, and for that I'd like to put on the screen a slide R51, and if we can have the appropriate part magnified, you will see there that the buyer is listed as Samir and the seller is listed as VMF Q1. So we really, again, this is another example where we dispute that we have failed to provide information that is relevant. We have provided that information. There was another reference that Mr. Harris has made, and again, there's so many of these, it's hard for me to really cover them all comprehensively in the time required, or that I'm limited to, and I am going to finish up rather soon. But the statement he made, as if it was a statement by Mr. Suvagia, is not true. It is from the excess carriers, and it is what the excess carriers said about Mr. Suvagia, not what Mr. Suvagia said. And I'm not going to go into that further because by virtue of agreements we've made, I can't go into the testimony, but the characterization as something that he said is incorrect. It's what the excess insurers carriers have said. Again, to the point which Mr. Harris keeps coming back to with respect to management shares and management agreement, under paragraph 1 of the management agreement, and this is true in most of these cases, but here we have CCM had sole discretion to handle the investments, and Mr. Harris pointed out some limitations, but again, sole discretion trumps all of the restrictions there. And again, with respect to the whole dichotomy that Mr. Harris seeks to make between participating shares and management shares, it is abundantly clear from the documents and from the testimony that these are the shares, the participating shares are the ones that reflect the losses, sustain the losses, not the managing shares. And finally, I'd just like to put one document up on the screen, and I think that basically will be the last thing that I say, and that is the forbearance agreement. If we could put that up, please. All right, now, so we have looked at this before. This is an agreement that says that the government of the Kingdom of Morocco froze Samir's bank accounts and directly or indirectly expropriated commodities. And again, the reason I raise this is because somehow Mr. Harris has tried to portray what Samir says as if it is not worth consideration. But the fact of the matter is this was an agreement that was signed by Samir that pointed directly to the government's actions as being responsible for the events that occurred and the losses that were suffered, and it expressly explains that. So again, to be quite frank, there are still a number of issues that we would like to have some opportunity to address, and whether we do or not is up to the tribunal. But I think I'm close to up in terms of my time. I've pointed to just a few of the mischaracterizations and misstatements, and I'd like to close by saying that in our position, none of what I've heard Mr. Harris said should in any way divert the tribunal from reaching the conclusions that we think are appropriate, which is that we have made a prima facie case, and on every level, with respect to all of the requirements of the investment, with respect to control, where we think the evidence is very compelling, with respect to the entire issue of in the territory of, with respect to objection number 3, where there again we could provide significantly more authorities that would support our position, but we believe that that is not necessary to do so. And if the tribunal would want us to do so, we'd be glad to provide more. But our position is that we have made that case, and that the tribunal should allow the claimants an opportunity to go forward with the merits of the case. Thank you.
Thank you. Thank you very much, Mr. Ordway, also for keeping within the time. And I will now give the floor. I don't know who wants to take the first step, either Professor Tijera-Naón or Mr. Wordsworth, if they have any questions. Mr. Wordsworth, any question for any of the parties? Or Mr. Yes, please.
I do have a question for Mr. Ordway, without prejudice to Mr. Harris, if he wants to make any follow-up answer. But you have made an important argument based on the influence of CCM in controlling the investments. And I would like to better understand how that control would find expression in respect of 2014. We got some testimony in that respect during the hearing. And secondly, if any, in respect of the trustee under the indenture, the trustee being specifically the State Street Bank and Trust Company. If this is my question, I hope it is clear, Mr. Ordway.
Yes, well, again, I think that the relevant agreements, which we could go back to, the relevant agreements do cede virtually all discretion and the exercise of all significant rights to CCM. And it is by virtue of the rights that were ceded to CCM that we believe that control comes into place. And it is essentially a complete control by virtue of those agreements. And that in no way affects the fact that that control is no way affected by the position of the trustee. In terms of the actual management of the funds, if you'll recall, CCM had complete discretion to transfer funds from one of the entities to another. That is from Q1 to 2014-1 to 2015-1. And that discretion, which enabled them to move the funds from one to the other, is critical to understand why we believe that there was complete control. And this could be done at any time by CCM. And the State Street had the trustee could not in any way impinge on that. And by the way, I might add that one of the things that Mr. Harris has said in his presentation is, well, and there was the opportunity and there's a provision that provides for CCM being terminated. That's all well and good, but at no time was it ever terminated, and there's no evidence that there was even consideration of that termination. So for all practical purposes, throughout the relevant period, CCM had the control. So I hope that addresses your question.
Well, I understand the trust structure, according to the indenture, as a security structure for the benefit of the holders of the notes, to ensure that if there is any failure, any default in the payment, that those assets could be applied by the trustee to ensure the repayment of the notes. That's my understanding of the indenture. If I am wrong, you correct me. But that implies that there is fiduciary title over the commodities, the futures contracts. I would imagine, you correct me, the put option in favor of the claimant. So in which way CCM can exercise any control on that?
I'm sorry, you said in favor of the claimants. Was it really the claimants, or was it in favor of the note holders?
Well, the security structure is in favor of the note holders. That is clear. But in which way the actions of the conduct of the trustee can be influenced by actions or omissions of CCM?
Yeah, that is the question.
If I spoke, my apologies. Thank you, Mr. Chairman. But that is really my question.
Well, again, would Mr. Yohai be in a position to address this issue? I could do so as well, but maybe Mr. Yohai would like to do so.
Yes, I mean, what I can say about this is the following. The notes had the trustee, but CCM, as Mr. Ordway has explained, had the ability to transfer funds from the notes to be utilized for these investments. So while they were paying a coupon on the notes, the funds at issue were controlled by CCM. And so when they did the investment, CCM was the one who directed the actual investment. So to the extent that the trustee had any role at all, the trustee, yes, had, I would say, notional title at that point in time, but the title that the trustee held was only for the benefit of those note holders. The money, the investment money, was fully controlled by CCM. And in fact, the trustee played almost no role in this. There were routine reports to the trustee, but beyond that, the trustee had no role in directing the investment.
So what you're saying is that the underlying assets, whatever they are, commodities, future contract, they were not under the control of the trustee. You're saying that?
The underlying assets were not under the control of the trustee. The CCM had control. The trustee was there, and CCM did report to the trustee, but the trustee could not direct CCM to do anything. It was only be if there was a default,
yes,
the trustee could step in. But there was no default declared, and so therefore CCM was in full control until there was such a time as whether the trustee declared a default, which it never did.
So that's your position.
Yes.
But absent an event of default, then the control on of these assets remained with CCM.
Correct. Correct.
Thank you.
Might I say something?
Of course, Mr. Harris.
I'll be very short. First point, it's abundantly clear that CCM could not control the trustee. Second point, there's no agreement even suggested in that regard. Second point, just reacting to what Mr. Yohai has just said. It seems that their position is that CCM, before repaying the note holders, could simply get rid of, transfer to another Carlyle entity, all of the assets of 2014-1 without the State Street Bank trustees' consent, such that it could effectively deprive that security mechanism of any meaning at all. Because on the case that Mr. Yohai has just explained it, CCM, Mr. Zuek sits there and he says, well, we'll just take all of the assets out of 2014-1 and put them somewhere else. And State Street Bank has nothing to say about that. It's the trustee, but it's lost all the assets. We say that just cannot possibly be right.
May I respond?
Yes, Mr. Yohai.
On the front end, there was no role for the trustee to do anything with respect to CCM. It would only be if the trustee declared a default that it would take control of those assets. So what you posit is exactly right. What you say I'm saying is exactly right. There's no inconsistency. And the record is very clear on this point. CCM was the one controlling those assets. They weren't depriving the note holders of anything. In fact, when an investment was to be done, CCM would do the investment. It didn't call up the trustee and ask if it could do the investment or get the trustee's consent to do an investment. It did the investment.
So if I understand what you're saying, Mr. Yohai, and I'm not saying that that's the way my thoughts go. What you're saying is that only if there is an event of default, that possibility that was presented by Mr. Harris of transferring the assets somewhere else couldn't happen, only after an event of default. It would be part of the rights of the trustee to make good the rights of the secured parties.
That is correct.
That would be your idea. Okay.
Very good. Anything to add, Mr. Harris?
Not on that point, sir. No.
Very good. Any further question, Professor Agrigeranaon?
No. Thank you very much.
Mr. Wordsworth.
Very much. Can I ask a question to Mr. Harris about Article 1015, which is just to leave to one side the issues on context and on Article 33.3, just focus in on the ordinary meaning of 1015. And I understand the case that really the words on its own behalf are interpreted as a sort of funnel. So they sort of narrow the scope of the claim that the investor can bring. Now, if one looks at 1015, we see the claimant on its own behalf may submit to arbitration under this section a claim that the respondent has breached an obligation under Section A. And then if you look at Section A, of course, that's going to provide an obligation, so let's say under the FET provision, to accord FET to covered investments. So if you look just from the perspective of ordinary meaning, it may look as if you have this funnel at the beginning of the provision with on its own behalf, but then it seems to funnel out again, given the broad definition of investments as covering direct or indirect. And I just wonder, is that some sort of an inconsistency, or how does the funnel operate there?
I think I apologies. I thought I had dealt with this earlier, but obviously not sufficiently well. That isn't in my submission. There's no widening after the funneling. The funneling is there, and it is simply that the claimant on its own behalf limits it. But the question of the breach that is relevant can be any of the obligations of the state towards the investment. Now, if I've understood correctly your point, it's the point that Mr. Ordway made that I tried to respond to, where he says, well, you can own and control an investment directly or indirectly, so why can't you claim? And that's the example we gave, that indirect is under B and direct is under A. And so you can have both indirect or direct ownership or control of assets. And so under A, the claimant can only claim for on its own behalf, therefore for things that it directly owns or controls. So it's a narrow funnel.
That's absolutely right. And yes, and of course I understood all those arguments. And it's just whether it could be thought to be imperfect wording, because of course there is the funnel there on your case, but it does, if you then look at the provision, it seems to be taking you towards investment as broadly defined, to cover direct or indirect investment. So I just wanted to know if there is any other argument on ordinary meaning to help us with that, or if the only argument is, well, yes, absolutely, under this treaty, indirect or direct investments are covered, but they disappeared down different routes by reference to 1015(1)A and 1015(1)B.
I think the point we made is that investments can be held directly or indirectly under the investment definition, but under the who can bring a claim definition, there's a difference between who can bring claims in relation to such investments, and that's what we've tried to. I don't think I can develop it much more than that, I'm afraid.
Fine, thank you. And then can I ask a question of Mr. Ordway?
Yes.
Which is that you said, while looking at some of the issues of fact that the respondent has been raising, you referred to At this stage of the inquiry, it's a jurisdictional inquiry, and we've submitted plainly sufficient evidence to establish a prima facie case of jurisdiction. And I just wanted to understand a bit further what you meant by that, just by way of clarification. Because there are obviously cases, is it a contract case, is it a treaty case, where you look at a case to see whether there is a prima facie treaty case in front of you. But there are also cases where at the jurisdictional phase, you're having to establish, does somebody have nationality? Does somebody own such and such an asset? Because it's a positive jurisdictional issue. And I understood your case there not to be one of, oh, it's sufficient for us to make a prima facie showing on the facts, but rather the burden of proof applied. And you were saying, well, Mr. Harris is wrong to say there's any heightened burden of proof here. You just apply to the facts that you have to dispose of at this stage, tribunal, i.e. facts which are truly jurisdictional. You just apply the balance of probabilities. So it's just to clarify what you meant.
Yes,
by referring to a prima facie case of jurisdiction.
Fair enough. And what I really meant is that we believe we made a prima facie case prior to respondents' objections, and that the objections were without basis, and that we have now supplied additional evidence to support our position on jurisdiction, and that we meet the requirements both with respect to what qualifies as an investment, also that our claimants qualify as investors under the treaty, and that we fall within 1015(1)(a). So perhaps I understated really our position, which is that we believe we have complied with all the necessary jurisdictional requirements, and that the objections raised by respondent have not been sufficient to overcome our clear claim to jurisdiction based on the evidence that we have presented. So I'm not sure if that makes it any clearer, but we believe we have sufficiently proved jurisdiction such that we can move on to the merits stage of the case. That is our position.
So the question is not establishing prima facie jurisdiction, it is establishing jurisdiction.
Correct. And I actually understated our position. We have established a prima facie case before the objections, and our position now is that we have complied with all the requirements necessary to establish a full case for jurisdiction. Yes.
And insofar as any facts have to be decided along the way, the burden of proof for those facts is just the usual balance of probabilities.
That is correct. That is correct.
Thank you.
Mr. Wordsworth, can I just coming back to the question you asked me, I just want to make clear, I think it's implicit in the way you put the question very fairly. I was answering it on the basis it was put, i.e. leaving aside the other provisions in the treaty. So leaving aside reading clause B, 1017 and 1025. I wouldn't want it to be misunderstood that I was, because obviously we say as part of the fundamental interpretation exercise in Article 31.1, you don't just read the language of that one line, you have to read it in the context of the treaty.
No, I fully understand that, and I fully understand the potential force of all those other arguments. I just wanted to see if there was anything further to be added into the mix. That was all.
Thank you. I'm grateful.
Any further question, Mr. Wordsworth? No. Very good. It will be a pleasant surprise to all that I have just one very simple question, which I think is can be answered in twice a yes, but I wanted to be double sure that it is correct. And Mr. Ordway, I'm sorry, it refers to the management shares, and I know this is a slightly topical question, but let me double check two facts with you. First, the management shares exist at the level of the master fund and at the level of Q1.
I believe that that's true, yes.
And the second question is, they are not owned by Carlyle or any of the entities in the Carlyle group.
Well, I think Mr. Yohai may be able to address that question.
I'm not sure I can, sitting here,
Okay,
President. We'd have to look at that question. I think our position is that the participating.
Okay, if you could, how long would it take? Well, we'll speak about it, but I think it would be important that we know who is the owner of these shares, because at the end it is one of the co-owners of Q1, or one of the equity holders of Q1, and it seems relevant whether it is a Carlyle entity or it is someone how like we saw, like Appleby Trust Limited or some other of these type of.
Of course, it is our position that the participating shares are the more relevant, but we will investigate the question for you to see.
I completely understand that you say it's 99% and all the economic benefits go to the participating shares. I have understood that. Very good. So we must make a note that goes to the secretary and to the assistant that we do not forget about them. So we now have to wrap up. This has been long and these are tiring days, but I think it is best now that we are all together here that we make the additional effort that we wrap up. And so I should probably look first to Mr. Harris. We will need, of course, costs. We will need submission on costs. That is, I think you both agree that that is necessary.
Yeah.
But further to that, do you think that there will be do you feel that you need to do any further written submission or any further written act before we close this section of the procedure?
I think in our view, there's no need for any post-hearing brief unless you would find that helpful. Obviously, if there are going to be such things, then we will want to, but we think we've covered the points. The only other thing I should say, in fairness to my team, who've been working very hard on this case, and they're sending me lots of messages telling me that I must say this. So, for the note, when Mr. Ordway said he doesn't know where we asked for Mr. Subagaya's deposition, it's Exhibit R10. I've said it. I don't want to get into it, but I've said it. I thought I had to, in fairness to my team, who've done an amazing job.
Yes, that is very good. Thank you. But you think that nothing else in writing is necessary. So let me now double check with Mr. Ordway. Let me just, before you answer, Mr. Ordway, let me give you an idea. The tribunal, we will deliberate. I mean, I don't know if today we are too tired, but very tomorrow or the Monday we will deliberate. We may come back with some questions, and I think we should leave open the possibility that we send you some additional questions. At this moment, I really don't think I have any, but after a deliberation, there may be additional items. So we would then send you 1, 2, 3 questions and ask you to agree among yourselves on a deadline, and then on the size of the answer. But this is an unknown. This is unknown. I really don't know if this will happen, what will happen in deliberation. You know how it is. The outcome of the deliberations frequently is different than one had expected. But further to that, and so to that open issue, having heard Mr. Harris, Mr. Ordway, do you think, are there any points you would like to make a written submission on?
Well, and just let me say, before I answer that question, after I have, I do want to make just a correction on the record, because I think the fatigue affected me, and I made a misstatement with respect to one of the provisions of the FTA. But let me address your question first. I believe, as Mr. Harris does, that to the extent that the tribunal has questions about specific issues, we would welcome the opportunity to address those issues. As I said earlier in my closing rebuttal, there have been a number of issues raised by respondent in certain respects for the first time, or statements and references to treaty provisions. So if the tribunal thinks it would be helpful for us to address some of those issues that were raised, we would be happy to make a submission with the understanding that whatever submission is made would be a brief submission that would be limited in page length, but that would give us sufficient, obviously, time to do so. So I think really it's entirely in the hands of the tribunal. To the extent that the tribunal has specific questions, we would welcome them for, among other reasons, because it would give us an opportunity to address some of the issues that, because of time, we were not in a position to address fully in our rebuttal.
Very good.
And
so,
then, yes.
Yes, you wanted to
Yes,
say there had been a small mistake.
Yes, I wanted to note that there's a correction, because at one point, with respect to the whole idea of there being a financing, I had indicated that it is Article 10, 12 that should apply, and not Article 10. I reversed them. Our position is that Article 12, as stated by Mr. Harris, does not apply in the situation where, assuming arguendo, the tribunal were to consider this a financing. So if I could just correct the record on that, that's what I wanted to say.
Well, this is an important point. Your submission is that this is not a financing, that the investment here is, if I have understood you well, is the commodities and the put option.
Well, the commodities, the put option, and other contractual rights, okay, such as the rights to recover the funds. Yes.
Yes. I mean, and the MCTA, the CSA, the commitment letter, the terms and conditions, the confirmations, correct, the rights deriving from these documents, plus the commodity.
That is correct. That is correct. The only point that we were trying to make is in response to Mr. Harris's statement that, assuming arguendo that it were a financing, okay, it would not qualify under Chapter 12 of the agreement. And again, all I meant to do is correct my statement, because it's our position that Chapter 12 does not apply to that provision at all, because there are certain measures that are required under Chapter 12 that we do not believe that render it inapplicable. That is my sole correction, and that's it. And I'm sorry, please.
No. So because you see, I am slightly. I mean, this is a very. It's a subsidiary argument.
It is
Your argument is that if we do not say, if we dismiss your argument that the investment is the commodities and the contractual rights which derive from this set of documents,
yes,
that then you subsidiarily allege that it could be that the investment could be a loan. Correct?
Yes. I mean, assuming arguendo.
Yeah. So it's a subsidiary argument.
Absolutely.
And if it were a loan, which would be the article which we should apply?
Well, it's not so much of which it would be the article. I mean, we believe we fall under that, under the definition of investment on 1027. All
Okay.
we're saying is that the restriction that Mr. Harris claims would render that argument, unsuccessful, does not apply.
Okay, so that your subsidiary argument, Mr. Ordway, is if we find against you that the investment is not the commodities plus the contractual rights.
Yes.
And if we accept your subsidiary argument that it is a loan under paragraph C of the definition of investment,
that's correct.
Then we should apply to that investment, which is now the loan, the Chapter 10 investment provisions in Article 10.
Yes, that's correct.
Thank you. Understood now. Okay.
Well, again, I think we've made this clear, but per Article 10.2.3 of the FTA, Chapter 10 does not apply to measures adopted or maintained by a party to the extent they are covered by Chapter 12. And this is not covered by Chapter 12.
Okay, so it's not a financial service and we will not be under the financial services chapter.
That's correct.
Very good. Thank you. Thank you for the clarification.
Mr. President, just
yes,
for the
of course,
record,
Mr. Harris. Yes.
I don't have any argument to make. I just want to say that for the record, in case you missed it, which I'm sure you haven't, but it's footnote 88 of our reply where we set out why Chapter 12 would apply. I'm not asking you to look at it. I don't want to make any submissions about it. I'm just putting the reference down to make it easy for you.
But thank you, Mr. Harris. So your point is that if we go this path, then and we think and we accept the subsidiary argument of claimant that the investment is a loan, we should then, because of 10.2.3, go to Chapter 12.
Yes, and because it falls within Chapter 12, which means that under 10.2.3 it's excluded from Chapter 10, is how I would put it. But yes, the same point. And if you look at the definition of financial services as we've set it out, it's there.
Okay, if this becomes relevant to us, you can rest assured that we will send a question to both of you so that you have more opportunities to develop it. At this stage, I don't think it makes much sense that we delve deeper into this. This is a subsidiary argument to your main argument, and
that is correct.
So if this becomes relevant, you can rest both assured that we will ask you more about that. So then we will do the following. If this is agreeable to both parties, you need some instructions on costs, your cost submissions. So I would then, assuming that there are no questions from the tribunal, then the only submission which we expect from you is the cost submission, which I would recommend that you do it simultaneously and that you do it in a form of an affidavit from Mr. Ordway and Mr. Harris, in which you itemize the costs and you represent that these are the true costs. And I think just with that, that is sufficient. I don't think, except if you both think otherwise, that we will need further arguments about costs. Each of you have asked for the imposition of the cost on the other party, as has been argued. I don't think we need further arguments on that. And so my recommendation to both of you would be on a date which you should agree, you will simultaneously present your cost submission in the form of an affidavit from both of you with a breakdown of the costs. So, Mr. Harris, would that be agreeable?
Subject to one point. I think I'd need to check, but I think I'm not allowed under my professional conduct rules to put in an affidavit.
No. Don't take it as a technical. Sorry,
yeah.
As a I mean, I need something signed by you saying that these are the costs which have been. When I said affidavit, I used it in a very loose system. In just that, I need something written by you where you say these are the costs, and the tribunal will trust that you have checked it, and these are the true costs. That is what I was expecting from you.
I was going to say, if you want anything more like a witness statement or something, then we will get that done for you, but it just won't come from me.
No. Something from you. We would like something from you in which you declare these are the costs in a way which is in accordance with the standards of your profession.
And that's just numbers that you want.
And items. You please itemize. Yes. Itemize the numbers, and it's a 2-page. I mean, these are it's a 2-page document. And Mr. Ordway, I would then expect the same from you, that you say these are the costs which have been incurred. Itemize them as much as you can itemize them. The better, because it goes to proving more the reasonability of the costs. And you then submit it at a mutually agreed date simultaneously.
And Mr. President, given that we're dealing with a very exhausted team, we would ask that, this would not be a matter of days. We'd have at least.
No. I was going to say, and that is, Ms. Pines, thank you, is I really would like to thank those, and I will now ask that everyone who has been working on this case, please put on their if they are not in pajamas, but if they are, that so that we can have a look at them and thank them, and thank all of them for the work. And these hearings are exhausting. You have done an amazing job, all of you, in very short time, and you have reacted to. I know that it must be extremely demanding on the teams when you have the closing submissions on a Friday, and you had all the witness and experts on the Thursday, and I'm sure that many of you have not slept tonight. And we really wanted to say 2 things. First, it was excellent job, excellent work, really very, very high quality international law work. And the second thing is thank you. It is very much appreciated how much you have worked, and we will try to apply the same standards of quality when we write the award. So, and then the next thing is, I am now speaking on behalf of Mr. Ordway and Mr. Yochai and Mr. Harris. You deserve a week's holiday. Very good. And the same goes to our court reporter, to Diana Burden. It must have been exhausting because these days are long. And thank you very much for the effort, and thank you very much for that. And then also to our FTI team, I don't know where they are. There they are. Thank you very much. Excellent, no glitch. Everything has worked perfect. And very often when things work perfect, one takes them for granted. But of course, nothing is granted. I'm sure that a lot of hard technical work was behind that. And really, it's amazing. It's amazing how technically, I don't know, we must be in 7 or 8 or 10 locations. And there has not been one moment when the lines have broken down, or when the quality of the technical quality of this is excellent. So thank you very much. And yes, I think this will now bring our hearing to the end. Enjoy the weekend. don't work on this weekend. This is off the record, Diana, where I encourage the holidays and encouragement not to work are always off the record. Enjoy the weekend. Thank you for all your hard work. And if I can ask my colleagues that if we can stay and we can then wrap up on our side the hearing, that would be appreciated. So
Mr.
with
President,
that, yes.
Check one point.
Of course, Mr. Harris.
I understood. It was what I was trying to get at before. I understand you want a cost submission in terms of you want a statement of costs.
Yes,
do you
sir.
want? Have I understood correctly that you do not want any comments on opposing party costs or any submissions on the principle of costs?
No.
Very
Except if you feel very strongly, but no, it is my normal way of doing this is not. But if you both insist that you want to make a 10-page allegation on costs, I mean, we are in your hands. But in principle, with a cost statement that would be sufficient. But
No, I just wanted to meet your expectations.
That is my expectations. But as always, if you both think otherwise, then we are flexible. Yes, Ms. Rosenberg.
Mr. Armisto, Mr. President, one final point which may affect the deadlines for the cost submission is the corrections of the transcripts.
Yes.
We had put in the procedural orders 4 weeks, but
yes, let me try to reduce effort and thank you for reminding me of that, Ms. Rosenberg, and that is the correction of the. There is nothing more. First of all, we can go off the record now, Diana, because this is and you can relax a little bit now, and we will then close it afterwards. The quality of the of transcription nowadays is excellent, and with Diana Burden, it's excellent. So there are very few corrections, and there is nothing more boring for someone to go through pages and pages of the transcript in order to correct small mistakes. And I think it is an unnecessary effort. So I would propose that the following, that I normally now do not do a formal review of the transcript. If there is, if you find, if anyone and in the post-hearing work finds blatant mistake in the transcript, please bring it up within 4 weeks, and we will then solve it. The same with the tribunal. If we find when reviewing the transcript a blatant mistake, we will draw your attention to that, and we will then correct the transcript. But otherwise, let's assume prima facie that the transcript is correct, and let's avoid this boring and senseless work of having a junior lawyer reading through the transcript. Mr. Harris, is that agreeable?
Absolutely.
Mr. Ordway?
It's certainly agreeable to us.
So now we are back on the transcript, and so the what we will say is that the transcript only there will be no correction of the transcript only if the parties or the tribunal find a blatant mistake in the transcript. Then they will raise it within 4 weeks for the parties and for the tribunal before the issuance of the decision, and otherwise we will all accept that the transcript is prima facie correct. Very good. Is there anything else?
Only to thank you all, members of the tribunal, for your hard work in preparation and for hearing us out and devoting so much time to this, sitting late. We're very grateful. And to Diana, of course.
It is our duty. Mr. Ordway.
We echo those sentiments, and on behalf of the entire team, we thank you for the attention that has been paid to this case and for your service. Thank you.
Sam, Horacio, anything to add?
Thank you.
Except that everything is, we are very grateful to the parties and to the work of their support and to the work of ELA.
Excellent. Very good. So have a relaxing weekend, all of you, and thank you all. And we'll see somewhere we will meet again, hopefully not virtually, but physically, but for the time virtually. So thank you to everyone. And